Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court. We turn our attention today to the state of Georgia in the case of Georgia versus Donald Trump et al. In the matter of whether or not the prosecutor, Fani Willis, should be disqualified from the case. Fani Willis had been accused of self-enrichment in the case by hiring her paramour, who was paid a substantial amount of money, including, and more than her, to be quite honest. He was paid a lot. And then also benefiting from that she received gifts and other financial benefits from this that might have corrupted her. And there was a whole thing that he would take her on trips and she would pay him back in cash, so they said. And there's no record of any of this. You know, everything's cash. No records of anything, no deposits, no withdrawals, nothing. Everything is just cash exchanging hands. That sounds really plausible. I don't know about any of that. And so the question is, in part, well, twofold. Is there an actual conflict of interest, and is there a perception of a conflict of interest, and what do we do about that? And what is the relevant legal standard when it comes to disqualifying the prosecutor? What is the legal standard? And Fani Willis argued, and it seemed to be correct, that the standard was actual conflict of interest. But the judge in their ruling seems to have said to the office, make a choice. You can disqualify yourself, or you can disqualify the paramour. You got to disqualify one of you. And of course, the choice there is easy. Fani Willis disqualifies the paramour and stays on the case. But of course, what is really important is the ruling. What is the rationale of the judge? What is the judge's legal reasoning? What is the judge's legal reasoning for ruling this? And why does the judge think the way they do? So we will read the decision and try to understand the judge's rationale and try to understand whether or not we think, or at least I think, it is a decision in accordance with law, at least as the judge explains it. So this is an order on the question of disqualification. Let's go ahead and get started with this. On January 8th of 2024, the defendant, Roman, who's just one of the criminal defendants, filed a motion to dismiss the indictment and disqualify the Fulton County District Attorney's Office. So if we disqualify Miss Willis, because she is the prosecutor, it would, by operation of law, disqualify the entire office. Disqualify the head, and everything else falls. A co-defendants later joined and supplemented the motion, raising additional grounds for disqualification. Among other allegations of disqualifying conduct, the defendant contends that the district attorney obtained a personal stake in the prosecution of the case by financially benefiting from her romantic relationship with Nathan Wade, whom she personally hired to lead the case. He got paid a lot. He got paid more than her. He took her on trips. She apparently reimbursed him, so according to her, all cash. She didn't benefit, don't you know? But it seemed in the literal sense incredible, particularly in this day and age. No records, no receipts of this kind of money for this period seems sus. Let's press on. More specifically, defendant Roman alleges that the district attorney and the special assistant district attorney Wade, who doesn't work for the office but was hired by the office, he's a mercenary in this situation, traveled together on multiple vacations with Wade, covering many of the associated expenses. Defendant Roman later supplemented his motion with receipts from some of the travels. The state responded with an affidavit arguing the district attorney had not received a financial benefit through her relationship with Wade, and that the personal travel expenses were roughly divided equally by supplementing with cash. Where the cash come from? We just happen to have it. Miss Willis just happens to have cash in her safe at all times. She has tens and thousands of dollars in cash at all times. This is just a cash society. Okay. As alleged, the claims present a possible financial conflict of interest for the district attorney. Self-enrichment. More importantly, the defense motion and state's response creates a conflict in the evidence that could only be resolved through an evidentiary hearing, and one that could not simply be ignored without endangering a criminal accused's constitutional right to procedural due process. If she's corrupt, then that offends the law. After receiving 2.5 half days of testimony, during which the defendant was provided an opportunity to subpoena and introduce whatever relevant and material evidence they could muster, for example, the bank records, which apparently don't exist, the court finds the defendant failed to meet the burden of proving the district attorney acquired an actual conflict of interest in this case through her personal relationship and recurring travels with the prosecutor. All right, so actual conflict of interest versus perceived conflict of interest, right? Is there a conflict of interest in reality versus is there a perception of conflict? Now, if you're a judge, the judicial canons of ethics require you to maintain both. You know, justice must be done and must be seen to be done, as is commonly said. So if you're a judge, it's important that the rulings are in fact neutral and also that they appear neutral. That isn't, of course, to say that you as the judge can't rule lopsidedly for one-sided, because neutral doesn't mean even, right? Just because the ref is always ruling for one side doesn't mean the ref isn't neutral. Perhaps one side deserves to always have it called for them. The neutrality does not imply evenness in ruling. It does not imply evenness in outcome. Neutrality does not imply equality of outcome. It implies equality of process. It implies equality in an application, but not in outcome. So both are important, right? So if the judge is always ruling for the prosecution or always ruling for the defendant, as the case may be, that must in fact be the right reason, the right thing to do. And also, it must appear that the judge is doing it for reasons supported by law as opposed to external reasons, such as the judge is being bribed. Because at least in principle, it could be the case the judge is being bribed and the judge's rulings are also correct. That is the situation. The judge is being bribed, but it just so happens that the bribes are to favor a side that he was already going to favor in the first place. So the bribes have no actual impact on his decision. That is at least a hypothetical scenario. But the bribes make it look corrupt, even if it's not corrupt. You know, the judge was just like, yay, free money. I was already going to do that already. I already have my decision completely written. Wow, it already does exactly what they asked me to do. Just free money. I like money, so yay, money. But we don't really like that as a society because, well, even though the decision is in reality fair in this hypothetical, it doesn't look fair, and appearance of fairness is also important. Now, that's if you're the judge. If you're a party, this is obviously somewhat modified because as a party, you're not even supposed to be neutral in principle. A party is supposed to be, and in fact is commanded to be, a zealous advocate for their side. Neutrality is not the goal. In fact, neutrality is very much not the goal. You are supposed to, in fact, be a zealous advocate for your side, but for your side. So she is supposed to be a zealous advocate in this case for the state of Georgia, more specifically Fulton County, but not to enrich herself. Now, getting that line separated is a little more tricky because bias in principle, like I really like the prosecution. I think the state of Georgia is great, is not the kind of bias we're looking for. So teasing out that bias is a little bit harder. But that's still some of the things we're looking for, the actual conflict versus the perception of conflict. Is she actually conflict? Is she conflicted in reality versus the perception? The judge says no. She's not actually conflicted in reality because the judge apparently is going to say, well, you know, that she was going to prosecute this no matter what, which seems right. And she seems like and that Wade is sort of an incidental, not a motivating factor. But it appears dirty. So that's what the judge seems to be writing. Fine, let's read a little bit more. However, the established record now highlights a significant appearance of impropriety that infects the current structure of the prosecution team, an appearance that must be removed through the state's selection of one of two options. Defense motion is therefore granted in part. All right. On the question of actual conflict of interest, our highest courts consistently remind us that prosecutors are held to unique and exacting professional standards in light of their public responsibility and their power. The rules of ethics do specifically spell out special rules for the prosecutor. So the defense lawyer and the prosecution lawyer are not even in the rules of ethics. The prosecution has particular special ethics that apply to them. Namely, in principle, if you want to boil it down, to seek justice, not convictions. The defense's goal is to further their client's interests. Seeking acquittals is perfectly fine for the defense. But the prosecution is not supposed to, in principle, seek prosecutions. That is simply a extension of the goal, which is to seek justice. Now, how many prosecutors actually do that in reality is a whole nother set of problems. But again, in principle, every newly minted prosecutor should be instilled with the notion that they should seek justice over conviction, and they may strike hard blows, but never a foul one. Most importantly, prosecutors are expected to assume a role beyond mere advocacy for one side and must, of course, make decisions for the public interest, not their own personal or political interest. They serve the public as prosecutor in a very direct way and tangentially a slightly less direct way. So they must seek the public interest, which can include prosecutions, but may sometimes include not prosecute, which is where part of the idea of prosecutorial discretion comes from. A person might be guilty, but maybe we shouldn't prosecute this case because of external reason that would further the public's interest as a whole. At least you can have that sort of discussion. That isn't to say that you shouldn't prosecute it, but at least it's a factor that you need to fold into the analysis. There are broader duties because, of course, your duty is to the client, and your client at this point is the state of Georgia. So you must make sure to forward your client's entire set of interests to the maximum that you can. Recognizing these are not empty slogans nor toothless admissions, although they kind of are, without practical effect, although that's sort of true, Georgia courts have not hesitated to step in and use their inherent authority to disqualify a state prosecutor when required. That's a lie. They hesitate all the time, but that's okay. Especially when the prosecutor labors under an actual conflict of interest. Well, if it's an actual conflict of interest, then yes, that for sure is the case, at least in the case law. But they don't exactly go out of their way to try to do that just as a matter of course, nor does anyone in any state. So yes, in principle, but in theory, not as much. Disqualification of a prosecutor due to a conflict of interest is thus not a creature of statute, so much as it is a judicial remedy recognized by our appellate courts. So this is the judicial branch policing itself to some degree, because the prosecutor, like all attorneys, is an officer of the court, which means that the rules that apply to the prosecutor are not strictly a matter of statute. The prosecutor obviously gets a lot of their confines of their role from statute, but there is role that exceeds that. There's role here that exists outside of statute. There's role here that exists merely as a creature of being an officer of the court. Every attorney is an officer of the court, and therefore the court at least has some authority that exists just because the court exists. It's inherent authority. They don't need any statute to give them authority. The authority exists because the judiciary exists. They give themselves the authority. They don't need the external thing to give them the authority. And you also see this, by the way, in the executive branch and the judicial and the legislative branch as well. There's sort of inherent power there that you don't necessarily need any sort of external statute to provide for. On a matter of public policy, as the administration of law should be free from all temptation and suspicion so far as human agency is capable of accomplishing the object. That is the goal, right? That's one of the reasons that you put on the black robes as the judge. Sandra Day O'Connor commented about this. It's like we put on the robe, at least in part, because it's representative of us literally cloaking ourselves in the persona of justice. Like justice isn't just a title, like you call Justice O'Connor or Justice Sotomayor. It's not just a title. The idea, at least in principle, is by putting on the robe, you're literally channeling the persona of justice itself. That's the idea. You literally put yourself away in favor of this other thing. Now, the human condition doesn't allow you to do that perfectly. You know, the human condition makes that difficult to perfectly do, but this is the aspiration. It's the goal. It's the thing to be reaching to. It is the It is the essence of the thing that we are supposed to be reaching to as the judge, and to lesser extent, other people in the system. Because again, the defense or the prosecution or the plaintiff or the defendant, as the case may be, are not supposed to be neutral in this way. But they do cloak themselves in a different way, because the attorney or the defendant does partially cloak themselves in the mantle of the defendant, because they are not, strictly speaking, completely themselves. They're supposed to further their client's interest, right? So the words from the attorney may or may not necessarily reflect their own personal view, because maybe the attorney is saying it not because they, in some sense, personally believe it, but because it is professionally in the interest of their client. And Justice Scalia talked about this idea, for example. He gave a lot of examples. Perhaps most famously in the flag burning case, Texas v. Johnson. He ruled that Johnson had the right to burn the flag. He also commented publicly about it on more than a few occasions, that he really detested his own ruling on a personal level, but he didn't see any other solution. So he never changed his mind. He never said he was wrong. He never said, geez, I wish I hadn't said that. But he did say, I don't like that I had to say that. And then, of course, he also famously commented that a judge who always rules the way that they want to probably isn't a good judge, which I think is correct. So Justice Scalia ruled in spite of himself, because he thought it's what the Constitution demanded, which, of course, is his job. These are the kind of things that they're talking about when the courts are writing about this kind of thing. The Georgia Supreme Court has most recently denoted conflicts of interest and forensic misconduct. And forensic misconduct is just a bad name for it, and I'm not sure how the state of Georgia, in its infinite wisdom, landed on the term forensic misconduct, because forensic misconduct just seems to mean polluting the jury pool. That's what it means. It's conduct outside of the courtroom that in some sense pollutes the jury pool. That's what forensic misconduct is. I'm not sure how we gave it that name. Conflicts of interest and forensic misconduct as two generally recognized grounds for disqualification. A conflict of interest includes acquiring a personal interest in the stake in the conviction. In such circumstances, no showing of prejudice is required. The mere corruption is enough if it exists, right? This is the difference between actual conflict and a perceived conflict, right? If I'm doing it for the monies, or if I'm doing it for whatever reason, then the fact that the defendant is not made worse off is not enough, right? The fact that the defendant was going to get exactly the same outcome no matter what happened is not enough. I'm corrupt. My corruption may or may not have impacted the defendant in this scenario, but we don't care. The corruption is enough. Okie doke. That's what they're talking about. This is so because the prosecutor's duty to the public, and again, the prosecutor does have special duties that do not exist for the defense lawyer. They are not even in this respect. If the prosecution serves the public writ large, the defense serves the client. I suppose they both serve the client. It's just that the client, in the case of the prosecutor, is the entire state, whereas the client for the defense lawyer is the guy. So they both serve the client, but since they have massively different clients, their burdens are different. The prosecution's duty to the public creates the additional public interest, because they're the client, that must remain unconflicted in every criminal case. You're supposed to serve the public, not yourself. A determination of whether the prosecution is laboring under a conflict of interest is fact-driven, because of course it is. In this case, the Special Assistant District Attorney, the Merc that we hired, Mr. Wade, manner of payment is not actionable on its own, which is true. The prosecutor is allowed to hire external lawyers for any number of perfectly legitimate reasons. The fact that we hired an external guy is not the thing. The fact that we paid him is not the thing. The fact that we paid him even more than the prosecutor is not the thing. Maybe that's okay. All right, fine. Whenever a private attorney like Wade is paid by the hour, as opposed to the prosecutor who's paid a flat salary, a motive exists to extend or prolong the assignment. Because attorneys get paid by the hour, when they do, of course, other arrangements are possible, But if an attorney is paid by the hour, there is some incentive possible for the attorney to extend the time because, well, they get paid more. And so there is some incentive for there to be malingering. So an attorney must keep themselves in check. That's also one of the reasons that attorneys have to provide billing to the client to show them what they're doing so that they can sort of justify their own rate, as it will. All right. This tension, of course, has long been accepted. The fact that a lawyer is somewhat incentivized to earn more money for himself is, of course, a tension that exists, but we've accepted that long ago. Attorneys are allowed to be paid by the hour. It's also a type of speculative status violation. Our courts have regularly denied as insufficient grounds for disqualification absent some other person. So yes, we're aware that every attorney who's paid by the hour is potentially biased, but because we've decided long ago that being paid by the hour is okay, incidentally, by the way, this isn't some magical bias that exists for an attorney. Everyone who's paid by the hour has incentives to somewhat pad their billing, to make it more difficult for themselves, right? So the temptation to pad the bill is not some magical temptation that exists for the attorney. It exists for anyone who's paid by the hour. But so we just take note that that's okay, but the mere temptation is not enough because we let people be paid by the hour. Thus, the oath of office of the mercenary, because they had to take an oath of office because they're working for the government, right? They're a mercenary, they're a private attorney, but now you're a special assistant district attorney. Congratulations, you're now the government private attorney. No problem, right? We can change our status from time to time, and we can have special statuses. It's not unheard of, right? We can have a guy who's just a guy, and congratulations, you're now the government. Congratulations, whatever, right? It's for this purpose, you are this thing. Congratulations. You have accepted this status, and that is your status for as long as it lasts. Great. So they took an oath of office because they are now the government. Fantastic. The oath of office, in combination with the supervision, theoretically provided by a neutral and detached district attorney, should generally be sufficient to dispel the appearance of the improper incentive. If the hiring authority were doing their job, they would help keep their employee / their contractor in the situation. More of a contractor than an employee, but I digress. They would keep their employee / contractor in check. That's part of the role of the superior. Nor would a romantic relationship between the prosecutor standing alone typically implicate disqualification, assuming neither prosecutor had the ability to pay the other as long as the relationship persisted. So a mere office romance doesn't necessarily do the trick either. But in combination, as is alleged here by the defendants, the prima facie argument arises of financial enrichment and improper motivation, which inevitably and unsurprisingly invites a motion like this. So you are allowed to do the thing, but of course, if you do the thing, you do invite the inquiry into the thing. So that's what they're saying, right? It's like, yes, you are allowed to do these things, but these things look sus. There is a legitimate reason to do the thing, and there's illegitimate reasons to do the thing. And by doing the thing, which might be perfectly reasonable, you invite the inquiry into whether or not you're doing the thing for the wrong reasons, the wrong way, or otherwise are corrupt. So yes, you can do it, but it spurns the inquiry. So that's just part of the deal. If you're willing to accept that deal, then, fine. But that's why we are where we are. Okie dokie. As to the financial allegations, the court makes the following findings of fact. Reminder, this is a hearing because it is not the case, right? If you want the quick and dirty definition of what a jury decides as a matter of fact versus what a judge decides as a matter of fact, juries decide matters of fact that are about the case. Did the person do it? Did the witness see it? Hear it? Is that really the witness? Is that really the suspect's DNA? Is the crime lab corrupt? and so forth and so on. Juries decide questions of fact about the case. Judges decide questions of fact that are not the case. This would be not the case. Nothing about the prosecutor being corrupt in reality, in perception, or any other way is the case. It has nothing to do with whether or not the defendant is guilty or not. It is not relevant in the strictest sense of relevance. What makes something relevant? Something is relevant, by definition, when it makes any fact in dispute more or less likely. That is something that is relevant, right? Did the person do the thing? It is relevant if it makes whether or not they did the thing more or less likely. That is what relevance is. Okay, is the judge being corrupt have anything to do with that? Does the prosecutor being corrupt have anything to do with that? Does the jury being corrupt, when there is a jury, does the jury being corrupt have anything to do with that? No, it does not. It does not. It does not make any fact relevant to whether or not the person did the thing more or less likely. It speaks to why the judge, jury, prosecutor might be doing the things they do. It might speak to impropriety in the process. It's not good, but it is not the thing. So the judge decides it because it is not the thing. It is external to the thing. So the judge is now the finder of fact, which is the whole reason we had the hearing in the first place. The judge heard the witnesses, and the judge is the finder of fact, and the judge now finds these facts. Fine. On November the 1st of 2021, the district attorney hired Nathan Wade. So these are statements of fact now, just to emphasize the point. These are, in fact, statements of fact. This is now reality. On November the 1st of 2021, the district attorney hired Nathan Wade to serve as the special assistant to the district attorney, in other words, a mercenary, and lead the investigation that produced the indictment in this case. The district attorney considered at least one other option before hiring Wade, extending an officer to the former governor, Roy Barnes, who declined. The contract allowed for a $250 hourly rate, a relatively low amount in Metro Atlanta. It is a relatively low amount in Metro Atlanta. I mean, yeah, that's a pretty low salary for a Metro. That's a low salary. $250 an hour is a pretty low salary, yeah. And contained a ceiling on a maximum number of hours permitted. Under the terms of the contract, Wade was not to perform more than 60 hours a week per month without written permission. No evidence induced indicates that Wade ever received permission to exceed these caps. His contract was renewed on 2 separate occasions. Fine. Between October 2022 and May of 2023, the district attorney and Wade traveled together on 4 occasions that resulted in documentable expenses. The expenses are documented. The payments between them, not as much. The first included an extended trip in October 2022 to Miami and Aruba aboard a cruise. Wade initially covered expenses for October 2022 trip totaling approximately $5,000. In December of 2022, the two flew to Miami for another cruise, for which the district attorney paid $1,400 in plane tickets, while Wade purchased passage for the cruise, along with other vacation-related expenses totaling approximately $3,700. In March of 2023, the two traveled to Belize, where Wade covered resort and restaurant expenses in the amount of $3,000. In May of 2023, they traveled to Napa Valley, where Wade covered airfare, lodging, and Uber rides to the amount of $2,800. In addition, the two described taking a number of day-long trips to Tennessee, Alabama, South Carolina, North Carolina, and other parts of Georgia. Sounds like me, kind of, in this respect, in my dating habits. That sounds very similar to something I would do. So, fair enough. The two also admitted to dining out on multiple occasions. I am a sucker for a good quality meal. I'm really a sucker for good service, by the way. That's the thing I'm really a sucker for. I really do like really top level service. It's like the wait staff knows what I want before I do. That's worth a premium. Anyways, they admitted to dining out on multiple occasions and taking turns covering the bill. With seemingly full access to Wade's primary credit card statements, and also, of course, Miss Willis's statements, the defense did not produce any evidence or further documented expenses or gifts nor were any revealed through testimony. In total, defendants point to an aggravated benefit of at most about $12,000 to $15,000 in the district attorney's favor. The district attorney and Wade testified these expenses were not meant as gifts and not designed to benefit the district attorney. If they were gifts, they might have had to been reported because they're gifts to the district attorney, and that comes with a whole bunch of gift-giving rules. Although I'm not an expert on such things, so I'm not going to comment as to whether or not they must have been reported or not. I simply note that there is an issue. Both testified that the attorney regularly reimbursed Wade in cash because she just happened to have $12,000 to $15,000 around in cash at her house. Where'd she get this cash from? She just had it for years. She got it $50 at a time from the cash back at the Safeway and the Kroger, don't you know? There's a lot of cash back, but okay. And if not, the district attorney covered a comparable related expense. For example, the district attorney testified that she reimbursed Wade in cash for the Aruba trip, which she estimated to be about $2,000, and that she gave him money for both cruises. She further claimed that she reimbursed Wade for the entirety of the Belize trip and that she paid for the Nappy Valley excursions. Finally, while Wade could have bought meals in 2020, which totaled more than $100, which seems to be the limit for gifts, she'd also regularly pay the meals. Such a reimbursement practice may be unusual, and the lack of any documentation, corroboration, certainly concerning. The judge is like, yeah, that doesn't quite make sense to me either. Yet the testimony withstood direct contradiction, was corroborated by other evidence, for example, her payment of an airfare for the two of 2022 Miami trip, and was not so incredible as to be inherently unbelievable. Okay, well, fair enough. I mean, the judge is the finder of fact, and that is a reasonable conclusion the judge could draw. Whether or not I would agree with it or whether or not you would agree with it is not the right standard. The judge is the jury unto himself in this matter. And so the question is, clear error, basically. Could any reasonable jury find this? Could any reasonable judge find this? Yeah, I think so. I would be a lot more incredulous than this judge. I'd come down a lot harder than this judge. But the judge is entitled to this. There is certainly evidence from which a reasonable jury, reasonable fact finder could draw these conclusions. So I cannot fault the judge as a matter of law. I can fault him insofar as I do not agree with it, but I can't fault him insofar as he's entitled to make the ruling and that there is evidence sufficient to make the ruling. Whether or not he's making the ruling. Now, of course, there is sort of the meta question here of whether or not he really believes that, or whether or not he's merely saying that because it gets him to the end goal, right? Does he know where he wants to be at the end of the day? And so he's saying that because he wants to get to the end goal, or does he really believe that? In other words, does his own end goal, assuming he has one, corrupt himself? So is this a non-corrupted conclusion? Is one that someone could make an argument over? But I digress. That gets a little meta. I will also note, for what it's worth, before we press on, that disqualifying the elected district attorney is a bit of a deal, and it should be a bit of a deal. The district attorney was elected in everything. There was an election, and they were voted in. They are the chief executive in this context. They are the district attorney. So disqualifying her is disqualifying the executive branch, and also is robbing the voters of their choices. The voters may be dumb for choosing this, but that's neither here nor there. The voters have voted, and that also has to be respected. So disqualifying her should be a bit of a deal, and I respect that. All right. However, as the district attorney herself acknowledged, no ledger exists. There is no record of payments. Other than a best guesstimate, there's no way to be certain the expenses were split evenly, and the district attorney may have well received a net benefit of several $100s. So it probably wasn't even, which, fair enough. Despite this, after considering all the surrounding circumstances, the court finds the evidence did not establish the district attorney's receipt of a material financial benefit as a result of her decision to hire and engage in a romantic relationship with Wade. Simply put, the defendants have not presented sufficient evidence indicating the expenses were not roughly divided evenly, or the district attorney was or currently remains greatly and pecuniarily interested. Pecuniarily means financially. it doesn't necessarily mean money, but it means something having monetary value. So if she was being paid in drugs, for example, or some other services, right? If there was an exchange of services, like I do this for you and you do this for me, if there's a financial benefit to it, it is a pecuniary interest. Just to, clarify the legal terminology. In addition, and much more importantly, the court finds, based largely on the district attorney's testimony, the evidence demonstrates that the financial gain flowing from her relationship with Wade was not a motivating factor on the part of the district attorney to indict and prosecute the case, which I think is the conclusion we all would agree with. Miss Wade, not Miss Wade, Miss Willis, Prosecutor Willis, is not being motivated by the money. Miss Willis, I keep doing that. Maybe I should just call her by her full name so I won't make the mistake. Fani Willis, 2 W names. I'm confused. Fani Willis is being motivated by, being the one to take down Trump. The money is at best an incidental. I mean, that much seems very true. While general motive for more income can never be disregarded entirely, thank you very much, Ronnie, Missing Light Switch Cover, for being a member for 12 months. We do appreciate everyone who helps to support the channel financially. It is extensively appreciated. And we appreciate you being here to do the analysis. Am I a Republican? Yes, I am a Republican. I am a Republican. Let's read further. While general motive for more income can never be disregarded entirely, the district attorney was not financially destitute throughout this time or in great need, as she testified her salary exceeds $200,000 a year without any indication of excessive expenses or debts. Similarly, the court finds that defendants have failed to demonstrate the district attorney conduct has impacted or influenced the case to the defendant's detriment. While prejudice is not a requirement for disqualification, again, we're talking about prejudice to the defendant, right? Is the defendant made worse off by this? So while prejudice to the defendant is not a requirement for disqualification, it is relevant to consideration of due process and defendant's requested remedy of a complete dismissal. Yeah, so if there is harm to the defendant, that obviously is something that must be considered. Defendants argue the financial arrangement contains an incentive to prolong the case, but in fact, there's no indication they're interested in delaying anything, which I think is also true. I think the district attorney has pursued this with all possible speed, and it isn't them that's slowing things down. I think that's a fair conclusion. Indeed, the record is quite to the contrary. Before the relationship came to light, the state requested trial begin less than 6 months after indictment. I mean, Miss Willis is obviously strongly incentivized to have this thing wrapped up well before election. So, I mean, duh, right? I mean, that's much better for her. So, of course, that's what she wants. Soon thereafter, the state opposed severance of the objecting defendant, who did not demand their statutory right to a speedy trial. So one of the defendants said, I want a speedy trial. One of them didn't. So we dealt with severing the trials or not. Right? Just because you don't want a speedy trial, by the way, doesn't mean one can't be forced on you. So one of them said, I want a speedy trial. One of them said, I don't. And the state's like, well, I oppose severance. Speedy trials for all. You might waive your right to a speedy trial, but I'm going to shove it down your throat. Now, there are counter considerations, by the way, of course, because the defense is entitled to some extent to potentially extend due to their own concerns. But that is something that has to be balanced by the court. It's not an automatic. I don't want a speedy trial doesn't mean you automatically don't get a speedy trial. Right? You can say, I don't want a speedy trial. You can ask for continuances and extensions. But it doesn't necessarily mean that you're entitled to it. And if in the end the court's like, well, based on everything considered, you're getting a speedy trial whether you want it or not, that's, potentially a correct decision. The state argued only wanted to try the case once. Fair. The state amended its proposed timeline to request the trial commence less than 1 year after the return of the indictment. And even before the indictment, the district attorney approved a grand jury presentment that included fewer defendants than the special purpose grand jury recommended, which is true. The grand jury recommended indictments against people, and she did not prosecute everyone. I think she prosecuted about half of them. I'd have to go double check the numbers, but that strikes me as something I vaguely remember. In sum, the district attorney has not acted in a way in conformance with the theory that she arranged a financial scheme to enrich herself or Wade by extending the duration. That's a very fair conclusion. I agree with that conclusion. Fair enough. Without sufficient evidence that the district attorney acquired a personal stake in the prosecution, or that her financial arrangements had an impact on the case, the defendant's claims of actual conflict must be denied. Fair enough. I appreciate that. I appreciate that. I would not be so reticent to, I would not be so able to credit the Prosecutor Willis's comments as the judge. I take her comments and her testimony on the stand in a much sharper light. But even with all that, I'm not sure, even with that much, I'm not sure I necessarily disagree with the conclusion. Because even if I concluded, as I am more akin to do, that she is lying on the stand about, you know, the financial benefits and all the rest, and she's lying about the contributions, she's lying about the benefits. Even if I conclude all that, I'm still not sure I can reach the end conclusion that there's no actual conflict, because she's not trying to enrich herself. She's trying to prosecute this case as fast as it can, or at least she's not overly extending that. You know, she's trying to prosecute this with all due diligence. So the money is a side effect rather than the thing. The money is not the thing that's corrupting her. In fact, in reality, I appreciate that conclusion by the judge. Even if I disagree with components of the decision, the end conclusion makes sense to me. The finding is by no means an indication by the court that condones this tremendous lapse in judgment or the unprofessional manner of the district attorney's testimony during the evidentiary hearing. So the judge does take the time to say that Ms. Willis's testimony was not professional, which I agree with. She was belligerent and fighty and dismissive and rude at times to the court, to be quite honest. So the judge calls her out for, you know, being a bit of a dick in his courtroom, which she was. I appreciate. Alan Parker gives 20 gift memberships. Thank you very much, Alan Parker, for your contributions. It is extensively appreciated. Rather, it is the judge's opinion in this case that Georgia law does not permit the finding of an actual conflict for simply making bad choices, even repeatedly. Fair. As a trial judge's duty to confine itself to the relevant issues and applicable law. Also fair, and I appreciate that. The judge is, of course, supposed to apply the law. That's their job. So the prosecutor making bad choices is not enough to show an actual conflict. Even if the prosecutor was in fact being enriched, it's not enough to show an actual conflict within this meaning. I appreciate that. Other forums or sources of authority, such as the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, or the voters of Fulton County, may offer feedback on any unanswered questions that linger. Fair. So if any of those respective authorities want to take action against Ms. Willis, that of course is their call within the confines of the questions that they are asked. I am but a judge asked this one question. I'm not trying to answer all questions. Other boards and other authorities may have other, more exciting questions, but that is for them. But those are not the issues determinative to the defendant's motion. I appreciate that. The judge understands their lane, and they're staying in their lane, and I appreciate that. Good judge. Good judge. All right, now moving on to the question of appearance of impropriety. This is interesting. This is interesting as a matter of law because it's unclear, or at least was unclear, and perhaps the judge is about to clear it up for me, whether appearance of impropriety was enough to disqualify Ms. Willis. The case law seemed to not really support that proposition, although I didn't do the deepest of deepest dives. You know, I read the briefs, and Ms. Willis's brief did seem to be, on the whole, a bit more persuasive on the law, that actual conflict appeared to be required. So I'm interested to see if the judge can educate me and you as to whether or not appearance of impropriety is sufficient to disqualify, and what appearance of impropriety, if any, existed in this case. So let's read on and learn some more things. Finding insufficient evidence of an actual conflict of interest does not extend the inquiry. Our appellate courts have endorsed the application of appearance of impropriety standard to state prosecutors even without finding of conflict. Not necessarily clear that that's what the case law says, but that's the way that the judge reads it, which is fair enough. The case law isn't exactly clear on this point, so there's reason to read it that way, although reason not to read it that way. It's not exactly 100% clear, and so the judge cites a couple cases that appear to potentially allow for this. The judge cites Battle v. State. Certainly a conflict of interest or the appearance of impropriety from a close personal relationship with the victims may be grounds for disqualification of the prosecutor. In a case called Greater Georgia versus State, a district attorney may not be compensated by means of a fee arrangement, which guarantees at least the appearance of a conflict of interest. In a case called Head v. State, a prosecutor's close personal relationship with the victim in this case may create at least an appearance of impropriety, appearance of prosecution unfairness based on private interests rather than one properly based on the vindication of public interests. In that case, the individual prosecutor who was the conflict may be disqualified. Also, by the way, it's worth noting here as we're reading this, it's not clear that we're talking about the prosecutor with respect to these cases. We're talking about a prosecutor, but not necessarily the prosecutor. And so if we're going to disqualify a prosecutor, that's a little bit different than disqualifying the prosecutor. Also, it's not 100% clear that when they talk about appearance of impropriety or appearance of conflict in these cases, that they mean that, because the cases also seem to say, all these cases seem to also find an actual conflict of interest. And so it's not really clear what they're talking about to some degree. It's not clear that there's just a perception alone, but I digress. In a case called Davenport versus State, granting new trial after concluding, under certain circumstances, there's at least an appearance of impropriety. Again, there might have been actual appearance there too, so it's a little bit hard sometimes to know what they're talking about. The cases cited here that result in disqualification do not hold that an actual conflict is necessary. That's why the judge reads it, fine. The question of law, it's a question of law. You could disagree with the judge's conclusion as a matter of law on this issue. I don't know enough to disagree with the judge's conclusions. There seems to be, if you did disagree with it, it would actually make the judge's decision less viable. It would actually favor Miss Willis. So the way that I sort of understand that if the judge is erring, she's erring in a way that he's erring in a way that if it's overturned, it would actually benefit Willis. So, before we get too excited about overturning this on appeal, it would seem like any appeal on the law would only benefit the prosecutor. The state nevertheless argues the facts presented suggest as much, and while that may be so in some instances, opinions do not make that finding. And the court cannot ignore the explicit language of the Georgia Supreme Court and multiple opinions from the Georgia Court of Appeals. So the state argued, and Ms. Willis argued, that actual conflict was required, and their reading of the case law could support that proposition. You could reasonably read, and again, I didn't do the deepest dive, right? I only read their briefs. I didn't actually go read the underlying cases. So maybe when you go actually read the underlying cases, things are not as they appear. But I did read the briefs, and at least the plaintiffs or the defendants, the people being prosecuted, they didn't sort of highlight why they thought that those were unreasonable reading. So you could read this language potentially dealing with potential conflicts or perception of conflict as dicta. Dicta basically just means an aside. So you could basically say, yeah, the court said that, but it wasn't necessary to their holding. It was just random musings, and therefore I'm going to ignore it. But the judge doesn't seem to think it's dicta. The judge seems to think that it is controlling, and therefore must be given actual controlling authority. Fair enough. I mean, it's a question of law, and without actually going and reading the cases in depth, I can't disagree with the judge. Further, while Davenport in the first instance is the first instance the court can find where the exact phrase appearance of impropriety is used to assess disqualification of a state prosecutor, the reference to Caesar's wife and the admonition against all temptation and suspicion demonstrate the principle has long been endorsed by Georgia law. Okie dokie, fine. While formally undefined in Georgia precedent, an appearance of impropriety is generally considered to be conduct or status that would lead a reasonable person to think that the actor is behaving or will behave in an inappropriate or wrongful way. Long story short, are they doing things for reasons other than the reasons they're supposed to be doing things? Do they have corrupt motives? Or do they have the appearance of corrupt motive? That's what we're talking about. Borrowing from federal judicial recusal standards, a reasonable person is not an uninformed member of the public with only passing knowledge of the facts at hand. This must be the standards. Otherwise, the case in this case is a causal, uninformed, or misinformed observer might believe the district attorney must recuse herself merely because her father shares a last name with co-defendants. So as we're judging this, our standard is not, someone who only reads the headlines. The reasonable person is informed in this situation. So the man on the bus, but they also know all the facts, as a jury would know, right? That's one of the reasons we tell juries the facts. That's one of the reasons we take the man on the bus and we transform him into someone who knows the things because we told them the things. So as we're judging whether or not a reasonable person would find that there's an appearance of impropriety, we don't mean just the man on the bus. We don't mean innuendo and gossip and rumor. We mean the reasonable person who knows the things. If they knew the things, would they believe it? That's what we're talking about. That makes sense. Because otherwise, well, the man on the bus might be ill-informed because maybe they watched The View. Nor is a reasonable person hypersensitive or unduly suspicious without an understanding of the relevant legal standards and judicial process. The reasonable person is tempered. The appearance standard recognizes that even where no actual conflict exists, a perceived conflict in a reasonable eyes of the public threatens the legal system itself. So even if there's not a conflict, if the sufficiently informed people think that there looks like there's a problem, then there's a problem. When the danger goes uncorrected, it undermines the legitimacy and moral force of our already weakest branch of government. That it is sometimes an attorney, guiltless in any actual sense, nevertheless is required to stand aside for the sake of public confidence in the probity of the administration of justice. You may have done nothing wrong, you may be blameless, but maybe it's better if someone else does this just to avoid the appearance of whatever situation. It's a little unfair to you, the person, but remember, to some extent, you're not the person. You're the prosecutor, remember? This is the difference between the person and the office, right? There's a difference, right? We're not necessarily coming after you in a personal way, although it can be a little hard to tell the difference if you're the person behind the mask. It's a little bit hard to say, oh, they're only attacking the mask, not the person. They're only attacking the robes, not the person. That's a little hard to sometimes hold if you're the person, but at least in principle, we understand what they're talking about, right? The court finds that it can and indeed must consider the appearance of impropriety as a basis for the state prosecution disqualification, especially in recognition of the critical role the prosecution plays in the criminal justice system. Our one final observation can be gleaned from careful study of our appellate decisions applying the standard. The remedy can vary. Fair enough. Just because we know there's a problem doesn't necessarily tell us what to do about it, right? Just because you know the defendant is guilty without knowing anything more, you don't know what the remedy is. If I tell you the defendant's guilty, what should we do about it? Well, you probably want to know a lot more things like, what is the defendant guilty of would be a helpful start. That'd be really helpful, right? As we're trying to figure out what the remedy is here, right? Should we let them go with a slap on the wrist or should we execute them? Probably want to know a lot more things, right? Yeah. Unlike an actual conflict, the finding of an appearance of impropriety does not automatically demand disqualification. Fair enough. Our Supreme Court has previously analyzed disqualification under an appearance standard in a civil case, which, isn't ideal because criminal law does come with additional baggage because of the Constitution. There are some fundamental rights that exist because it's a criminal case: the right to an attorney, the right to a presumption of innocence, the right to a fair trial by a jury of your peers, and so forth and so on. So, using a civil case in a criminal case or vice versa can get a little tricky, but if it's all you have to do, it's all you have because there isn't anything else. What else can you do, right? So it's like, let's go find some authority. We couldn't find anything. Okay, let's go find something that's close. So we found a civil case. Let's give that a shot. Using a continuum, recognizing disqualification is not the only appropriate outcome. At one end of the scale, where disqualification is always justified and indeed mandated, even where balanced against the client's right to an attorney of the choice. So once again, in this case, it seems like we're disqualifying the defense's lawyer. So we might be disqualifying the defense's lawyer despite the fact the defendant wants them, because justice demands it for any number of potential reasons. Also partly to protect the defendant against themselves sometimes. Is the appearance of impropriety coupled with a conflict of interest or jeopardy to the client's confidences? In these instances, it's clear that disqualification is necessary for the protection of the client despite themselves. Somewhere in the middle of the continuum is an appearance of impropriety based on conduct on the part of the attorney. As discussed above, this generally has been found to be insufficient to outweigh the client's interest in the counsel of their choice. And by the way, of course, you can, by extension, say that the client, of course, in this case is the state of Georgia, or perhaps more particularly, Fulton County, and the client, the people of Georgia, have, through their political power, selected the attorney of their choice by electing the prosecutor. So you could view it that way as well. So maybe it is the same thing to some degree. This is probably so because, absent danger to the client, the nebulous interest of the public at large and the propriety of the bar is not enough to justify qualification. Finally, the opposite end of the continuum is an appearance of impropriety based not on conflict, but status alone, and that is insufficient. For example, a family relationship. They're the daughter of, they're the son of, blah, blah, blah. That kind of thing. They're the cousin of, blah, blah, blah. They formerly worked with so-and-so. That's not enough. That kind of thing. The Supreme Court further noted that disqualification due to appearance of impropriety should rarely occur when there's no danger the actual trial will be tainted. So unless there's going to be a problem in reality, we probably shouldn't disqualify. Okay. When there's no claim the trial will be tainted, appearance of impropriety is simply too slender a reed on which to rest a disqualification order, except in the rarest of cases. In Billings versus State, although the Court of Appeals found an existence of an appearance of impropriety, it noted that appearance could be cured through screening the affected prosecutor from participation or discussion of the affected case. This is what we used to call a Chinese wall. There's a lot of different names for it. But one of the ways we can cure the problem is by segmenting off the person who is the problem, right? We put them in a box, as it were, and they are now segregated from everyone else, so their problem is no longer everyone else's problem. And particularly when you're not talking about the prosecutor. If you're not talking about the prosecutor and you're just talking about subordinate, then this is easier, right? You segment them off, you forbid them from doing anything about the case, you don't allow any communication about the case between them and anyone else, you give them other things to do, everyone moves on with their life. If it's the prosecutor, you can't do that. You can't segment off the prosecutor from the rest of the office because all authority flows from the prosecutor. The disqualification of the prosecutor necessarily disqualifies the entire office. But that's what they're talking about. Moreover, to ensure that no conflict of interest or appearance of one might develop, the district attorney took prudent step of ordering the investigator take no part in the investigation or prosecution of the case. So there was a problem, and they told them, hey, you stay out of it. These cases indicate a trial court can consider alternate solutions to cure the appearance of impropriety, which is fair enough. Disqualification is not necessarily the only thing we can do. There might be other things we can do. Nor would finding the appearance of impropriety on part of the district attorney herself, in contrast to an actual conflict, necessarily result in a disqualification for her office. Okay, that's interesting, because I would think it would, but the judge disagrees with me. I would think that if you did find an appearance of impropriety on the part of the district attorney, it might result in the disqualification of her entire office, but the judge just disagreed with me flat out. So, okay, justify that choice, I guess, Judge. I'm open to the possibility I'm wrong on the law. Teach me. The district attorney in a case called McLaughlin was absolutely disqualified due to a personal interest in the prosecution. As a result, assistant district attorneys appointed by the district attorney's attorney lacked any authority to proceed. Makes sense. McLaughlin did not address an appearance standard because it was an actual conflict, and made a point to limit the total disqualification to instances of absolute disqualification. I don't know exactly what absolute disqualification is, but okay. I don't know what absolute disqualification is. I don't think that's a thing. I just think the judge was just trying to be emphatic. The judge here is treating absolute disqualification like it's a category of a thing. I'm not sure it's a category of a thing. Okay, I'm doubtful. When the appearance of a conflict exists, only the affected prosecutor, be the elected or appointed, is affected. Okay, I'm not sure about that one. The individual prosecutor who has a conflict based on at least the appearance of impropriety may be disqualified from participation in the case, but not all other prosecutors who work with him. When they say that about the individual prosecutor who has a conflict may be disqualified, were they talking about the prosecutor, or were they just talking about a prosecutor? Because no one is disputing that a prosecutor may be disqualified, but not all other prosecutors who work with him. There's a difference between work with him versus work for him. So I'm not sure they're talking about the prosecutor. So I'm not really sure this authority is on point. I'm doubtful on the legal analysis here. All right, continue on. And then there is apparently a case called Frazier versus State, 1987, Supreme Court of Georgia, distinguishing Davenport, an appearance of impropriety case, by noting that this district attorney's disqualification did not result in the disqualification of the entire office. Okay, at the end of this, we're definitely going to have to go look up Frazier v. State, because that seems to be like the authority that this is relying on, which appears to be from the Supreme Court of Georgia. Did the Supreme Court of Georgia really say that? All right, we're going to have to go look, because I have my doubts the Supreme Court of Georgia said that, but we'll look. We'll definitely look. Note to self, please go look up Frazier versus State. With these principles in mind, the court finds the record made at the evidentiary hearing established by the district attorney, or establishing that the district attorney is encumbered by an appearance of impropriety. The appearance is not created by mere status alone, which is true enough, but comes because of specific conduct, and impacts more than a nebulous public interest because it concerns a public prosecutor. Even if the romantic relationship began after the mercenary prosecutor, Wade, initial contract, the district attorney chose to continue supervising and paying Wade while maintaining the relationship. She further allowed the regular and loose exchange of money between them without any exact or verifiable measure of reconciliation. This lack of a confirmed financial split creates the possibility and appearance that the district attorney benefited, albeit non-materially. I'm not sure about that. I mean, depends what we mean by materially, I guess, but all right. From a contract whose award lay solely within her purview and policing. Yeah, if she gained financial benefit, isn't that material? What are we talking about material? What do we mean by material? And albeit non-materially. I'm confused. I don't understand that quite exactly. Most importantly, were the case is allowed to proceed unchanged, the prima facie concerns raised by the defendant would persist. After the district attorney testified, her relationship with Wade has only cemented after these motions and is stronger than ever. Wade patently Wade's patently unpersuasive explanation for the inaccurate interrogatories he submitted in his pending divorce indicates a willingness on his part to wrongly conceal his relationship with the district attorney / lie. As the case moves forward, reasonable members of the public could easily be left to wonder whether the financial exchanges have continued, resulting in some sort of benefit to the district attorney, or even whether the romantic relationship has resumed. Put differently, an outsider could reasonably think the district attorney is not exercising independent professional judgment totally free of any compromising influences. As long as Wade remains on the case, this unnecessary perception will persist. Okay. The testimony introduced, including that of District Attorney and Wade, did not put these concerns to rest. During argument, the District Attorney pivoted from financial concerns to disapproving testimony of the District Attorney, namely that her romantic relationship actually predated the hiring of Wayne. On that front, the court makes a few brief observations. First, the court finds itself unable to place any stock in the testimony of Terrence Bradley. His inconsistencies, demeanor, and generally non-responsive answers left far too brittle a foundation on which to build any conclusions. While prior inconsistent statements can be considered as substantive evidence under Georgia law, Bradley's impeachment by text message did not establish the basis for which he claimed such broad, sweeping knowledge of Wade's personal affairs. In addition, while the testimony of Robin Yurti raised doubts about the state's assertion, it ultimately lacked context and detail. Even after considering the proffered cell phone testimony from defendant Trump, along with the entirety of other evidence, neither side was able to conclusively establish by preponderance of evidence when the relationship evolved into a romantic one. Okay, I mean, that's a judgment call by the that's a judgment call by the judge, and he thinks it's not on balance, but okay. However, an order of mendacity remains. The court is not under an obligation to ferret out every instance of potential dishonesty from each witness or defendant ever presented in open court. Such an expectation would mean the end to efficient disposition of criminal and civil proceedings. Yet reasonable questions about whether the district attorney and her hand-selected lead mercenary testified untruthfully about the timing of the relationship further unpin the finding of appearance of impropriety and the need to make proportional efforts to cure it. So he's not explicitly saying that I didn't believe the district attorney and Wade, but he's heavily implying it. It's not my obligation to spell out everything every time I find a defendant is lying, but reasonable questions remain. So I'm not going to say it, but I'm saying it. That they lied, and I didn't believe them. So, take notes. Ultimately, dismissal of the indictment is not the appropriate remedy to adequately dissipate the financial cloud. Fair enough. I don't think dismissal of the indictment was necessarily required for that. Dismissal of an indictment is an extreme sanction, only to be used sparingly as a remedy for unlawful conduct. Fair. There has not been a showing that defendants' due process rights have been violated, or the issues involved prejudiced the defendant in any way, nor is disqualification of a constitutional officer, which, again, worthy of note, they are the executive branch. So, there is that, and the voters have made a choice, so there's that too. Necessary when a less drastic and sufficiently remedial option is available. The court therefore concludes that the prosecution of this case cannot proceed until the state selects one of two options. The district attorney may choose to step aside, along with the whole of her office. So, I'm confused, because you earlier said that disqualification of Miss Willis didn't require the disqualification of her office, but now you're saying it does. I'm very confused. I don't understand. Why did you say that? Because you said on page 14, because I have a memory worth more than 5 minutes, you said when the appearance of conflict exists, only the affected prosecutor, be they elected or appointed, is affected. Then, citing this authority, the individual prosecutor has the conflict, may be disqualified from participation, but all other prosecutors work from them. Frazier v. State, distinguishing Davenport, an appearance of impropriety case by noting the district attorney's disqualification did not require disqualification of the entire office. So if we're dealing with an appearance of impropriety case, you don't need to put on subscriber mode for 20 minutes or longer. That's too excessive, moderators. Could you tone that down, please? You're more than welcome to put on a higher slow mode if you need, but can we not like make it so burdensome for people to join? I'd appreciate it. Unless we absolutely have to. Thank you. So you said that if this is an appearance of impropriety case, that we don't need to disqualify the entire office. You said that is law. And then you said, like, you said 3 pages later, the district attorney may choose to step aside along with the whole of her office. I don't understand. That doesn't flow. I don't get it. I don't get it. Your own statements belie yourself. That doesn't flow. If it's truly correct, that disqualification of the elected DA does not require the disqualification of the entire office. If that's true as a legal predicate, which you said it was three pages ago, then why are you requiring disqualification of her entire office? That doesn't flow. I'm very confused. I don't get that. I don't understand I don't understand what's happening. The district attorney may choose to step aside along with her whole office and refer the prosecution to the prosecution's attorney's counsel for reassignment. Alternatively, the mercenary can withdraw, allowing the district attorney, the defendants, and the public to move forward without his presence or remuneration, distracting from and potentially compromising merits of the case. Yeah. As to forensic misconduct, which is again a very bad name for the thing because it just means polluting the jury pool, the Georgia Supreme Court also recognizes forensic misconduct or improper comment by the state as grounds for disqualification. One example of such misconduct is expression by the prosecuting attorney of the personal belief of the defendant's gain. As guidance, Williams instructs the trial court should take into consideration whether such remarks were made as a calculated plan, evincing a design to prejudice the defendant in the minds of the jury, or whether remarks were more inadvertent. The case law also notes that while a prosecutor's comments may be considered improper, they must be egregious to justify disqualification. It's perfectly consistent. It's not consistent with what the judge said, David. That's the point. It's not consistent with the judge's predicate. It's not consistent. I mean, I can walk through it again if I wasn't clear the first time, but it's not consistent with the judge's own reasoning. Unless I'm missing something. I'm willing to read it again because maybe I'm missing something. But it doesn't seem consistent. Where is the writing? Oh, so it's here. So the judge has an entire paragraph about this. He has an entire paragraph about it. The judge writes, nor would finding the appearance of impropriety on the part of the district attorney herself, in contrast to an actual conflict, necessarily result in the disqualification of the entire office. So his entire point of this paragraph is if it's appearance of impropriety, and if we disqualify the district attorney, we do not need to disqualify the entire office. And then we cite some authority for this proposition, which I don't really think it says what the judge thinks it says, but this is what the judge says it says. He says the district attorney McLaughlin was absolutely disqualified due to a personal interest. As a result, the assistant district attorney appointed by a district attorney lacked any authority to proceed. In that case, McLaughlin did not address an appearance standard, and made a point to limit to total disqualification to instance of absolute disqualification. The judge treating absolute disqualification like it's a category unto itself. I don't think it's a category unto itself. It seems more like probably the judges were just speaking emphatically. Like they're disqualified in absolutely because they're just disqualified in every possible way. But the judge treats it like a category of thing. So the judge is distinguishing McLaughlin because, well, this isn't a case of absolute disqualification. Okay, I'm not sure that that's a thing, but the judge says it's a thing. Then the judge writes, when the appearance of conflict exists, only the affected prosecutor, be they elected or appointed, is affected. When the appearance of conflict exists, only the affected prosecutor, be they elected or appointed, is affected. And then we cite some case law on this proposition. The individual prosecutor who has the conflict based on at least the appearance of impropriety may be disqualified from participation, but not all other prosecutors. Frazier versus States. An appearance of impropriety by noting the district attorney's disqualification did not result in disqualification of their entire office. So you have an entire paragraph here in the middle of this opinion that says, hey, in the case of an appearance of impropriety, if you disqualify the DA, you do not need to disqualify the entire office. That's what this entire paragraph says. And then you move down 3 pages and you say, the court therefore concludes the prosecution of this case cannot proceed unless the state selects one of 2 options. The district attorney may choose to step aside along with the whole of her office. But that doesn't make sense. That doesn't make sense. Your entire premise for an entire paragraph was if this is just a mere perception as opposed to an actual conflict. If this were an actual conflict of interest, then the entire office would need to be disqualified. But if it's a mere perception of conflict, then it's not required. We had an entire paragraph explaining that to me. And then you move forward 3 pages later and you're saying, okay, the district attorney can either choose to step themselves aside along with the entirety of their office or fire Wade. That doesn't make sense. That doesn't flow. Why does the district attorney need to recuse their entire office? You just told me 2 pages ago they don't have to. That's a conflict. It doesn't flow. It doesn't make sense. Does that explain it any better? Does that explain it any better? I don't get it. So am I missing something? I don't think I'm missing something because that seems to be what it says. The phrasing by the judge implies he thinks actual should be found, but he's flinching from political pressure. Well, no, because this entire paragraph was within the section talking about appearance of conflict. There was an entire separate section with a header and everything. There was an entire separate section that dealt with actual conflicts of interest, right? So we had that whole discussion about actual conflicts of interest. And then we moved on to perception of conflicts of interest. So this paragraph is only talking about perceptions of conflict. It's within the confines in the opinion talking about perceptions of conflict, and by its own terms only talking about perception. So and the remedy here is within that section, right? Because the judge is about to move on to a different section, forensic misconduct. So the remedy only applies insofar as it applies to perceptions. So nothing makes sense. Dr. Stealthbug says, Kurt, if the elected DA says, then of course her whole office would have to. Either I'm not making sense. I don't know where the disconnect is coming. I don't understand where the disconnect is coming between me and you. And so I need to be better as a teacher. Because either I'm not understanding something. So one of 2 things is true. Either I'm failing to understand something, or I'm failing to teach you. And I don't know which of the 2 it is. So you have to help me out, okay? The judge is writing in sections, okay? Well, I'll show you, okay? So the judge, I'll just show you how it's laid out, okay? So, right, we have this order on disqualification. So we have like 2 paragraphs of introduction, and then we move on to the section actual conflict of interest, all right? The judge is telling you, hey, I'm now going to start talking about actual conflict of interest. Everything I have to say about actual conflict of interest is in this section. So the judge goes and talks about actual conflicts of interest for a while and talks about how he doesn't find an actual conflict of interest, and we've discussed all that. And I discussed how I thought the judge's conclusion was reasonable, even if I disagreed with their reasoning along the way. I was like, well, the judge made a finding. I don't think I agree with the finding, but I do agree with the conclusion. Right? So the judge talks about actual conflict of interest for a while, talks about that for a couple pages. Okay? And so we get to the end. And we're like, okay, we get to the end. We say, defendant's claim of actual conflict must be denied, right? We laid out everything there was to do about actual conflict. We laid out all the standards. We get to the end. We reach the conclusion. Defendant's claim of actual conflict must be denied. Okay, fine. So now we move on to another topic. We have a header and everything. Appearance of impropriety. Hey, I'm about to talk about this other thing. Appearance of impropriety. All right, so now I'm going to go talk about that for a while. So she talks about appearance of impropriety and whether there is an appearance of impropriety or not. And so she talks about that for a while, or the judge talks about that for a while. Then he has this paragraph. Jaredite, you are banned. Thank you for your super chat. Thank you for your donation, but you are banned. We do not allow open questioning of the moderators on the channel. You're welcome to raise issues in Discord, but we don't allow open questioning in the channel. You are banned. Thank you for your super chat. Let's move on. So, anyways, we're in the confines of perception of conflict, appearance of impropriety. Then we have this paragraph that talks about how if we find an appearance of impropriety, in contrast to actual conflict, nor would the finding of impropriety, in contrast to actual conflict, necessarily result in disqualification of the entire office. That's the entire point of this paragraph. A finding of appearance of impropriety does not necessarily result in the entire district attorney's office being disqualified. The judge then cites this case where the court did find a conflict and required the disqualification of the entire office. So the judge cites this authority that says, here's a situation in which they found something, but did require the entire disqualification of the office. The judge then distinguishes. It's like, okay, that's what that precedent says, but I distinguish. That precedent is not here because that case dealt with absolute disqualification and this case does not deal with that. Therefore, I distinguish the precedent. The judge then writes, when the appearance of conflict exists, only the affected prosecutor, be they elected or appointed, is affected. Only the affected prosecutor, be they elected or appointed, is affected. And then he cites authority. He cites Head, Georgia Court of Appeals. The individual prosecutor who has the conflict, based on at least the appearance of impropriety, may be disqualified from the participation in the case, but not all other prosecutors who work from him. Frazier versus States. An appearance of impropriety case, by noting the district attorney's disqualification, did not require disqualification of the entire office. So the judge's entire point here, for an entire paragraph, is mere appearance of impropriety is not sufficient to disqualify the entire office. He writes about it for an entire paragraph. Finding the appearance of impropriety on the part of this district attorney does not require disqualification of the entire office. That's the entire point of this entire paragraph. Then 3 pages later, he writes, the court therefore concludes the prosecution of this case cannot proceed unless the state selects one of two options. Option number 1, the district attorney may choose to step aside along with the whole of her office and refer the prosecution to the prosecuting attorney. That doesn't make sense. That doesn't make sense. 3 pages ago, you told me in no uncertain terms that if it's an appearance of conflict case, it might require the disqualification of the prosecutor, but would not require the disqualification of her whole office. You told me that in no uncertain terms 3 pages ago. And now you're saying, hey, your options are you can disqualify your entire office. And I don't understand that. I don't get it. It doesn't make sense. It doesn't flow. So have I explained this adequately at this point? Yeah, it doesn't. I'm willing to keep talking about it. It wouldn't necessarily require, but it might. Yeah, but the judge doesn't at any intervening point explain why this case requires that. So I appreciate that the judge says, like 3 pages earlier, wherever it is, the judge says, he says, nor would finding of appearance of impropriety necessarily result. So it doesn't follow, right? It is not necessary. It is not a matter of course. It is not required, right? Just because I disqualify the district attorney does not necessarily implicitly require me to disqualify the entire office. Okay. So, all right. So you are now going to, we know, because we read it 3 pages later, we know we're going to say that the district attorney should step down, right? Because that's what the judge is writing in that part. It's like, one of your options is the district attorney steps down, along with the whole of her office. But we just read, just now, it's not necessary. It doesn't necessarily follow. It doesn't implicitly follow. It is not an axiomatic conclusion. So could it follow? Could it follow? I guess it could, but the problem is at no point between the judge saying it doesn't necessarily follow and saying it should follow, does the judge really provide any reason why this case would mandate that result. So it's not required normally, but in this case, ... I'm going to require it because of, he doesn't really justify it. As although it's not necessary, generally it's necessary in the specific because of, he doesn't really justify it in the intervening cases, in the intervening things. So he talks about some of the facts. He talks about the prima facie case remaining, about why the district attorney can come on. He talks about the testimony. He talks about the odor of mendacity, unable to ferry out dishonesty, dismissal of the indictment not being appropriate, and then he gets to the remedy and says, oh, the district attorney can withdraw along with the entirety of her office. At no point in the intervening 3 pages did he provide a rationale or a reason for, like, okay, it's not normally required, but I have to do it this time. He doesn't provide any rationale. He just provides a whole bunch of facts, but he doesn't really tie it into the conclusion. So it doesn't flow. Because he doesn't justify the decision to do it this time. The judge removing her is different than her removing herself? No, it's not. It's not in this context. No, it's not. Because they're talking about because again, it's not different. Because they're talking about the finding of impropriety on the part of the district attorney resulting in the disqualification of the entire office. And then they say when the appearance of conflict exists, only the affected prosecutor is affected. So they're talking about a judge imposing this. I think that seems to be the context they're talking about, the judge imposing this, right? Because they talk about, if the, on the part of the district attorney necessarily results in disqualification. They talk about the district attorney in McLaughlin, who was in fact disqualified along with the entirety of the office. And then the judge distinguishes, okay, this case is not that case. This is not a case of absolute disqualification, whatever the hell that means. I don't think that's a thing, but the judge thinks it's a thing. So I distinguish the case. When the appearance of conflict, only the prosecutor is affected. Well, they're affected by being disqualified. That's what they're talking about. This is the judge imposing it. So it's not the prosecutor doing anything voluntarily. That is not the context of what we're talking about. That is not the right solution. When given the alternative, it's not an absolute disqualification. But that doesn't solve the problem. That actually doesn't solve the problem. If it were a case of absolute disqualification, if this were a case of absolute disqualification, then the judge says that would require the disqualification of the entire office. That's what he says. The district attorney in McLaughlin was absolutely disqualified. As a result, the assistant district attorneys lacked any authority. Right? So if this were a case of absolute disqualification, then there is only one remedy. There is only one remedy, right? Then it must be that we're disqualifying the prosecutor and the entire office. But this is not a case of absolute disqualification, because that's the point of distinguishing. And then the judge makes it clear. The judge makes the distinguishing clear. When the appearance of conflict exists, only the prosecutor, be they elected or appointed, is affected. So if this is not a case of absolute disqualification, only the affected prosecutor is affected. And the judge says this is appearance of conflict case. That's the entire point, right? Because we're inside the appearance of conflict case. That's the point. So if we're inside the appearance of conflict case, then only the prosecutor should be affected. But then 3 pages later, it says the district attorney may choose to step aside along with the whole of her office. That doesn't follow. It doesn't follow. Nate the lawyer was fired up over this ruling. Okay, well, he's entitled to his own legal analysis as I'm entitled to mine. I'm providing you my legal analysis and my thoughts on the reasoning. I like Nate the lawyer very much. He may or may not disagree with me. Maybe we can have an intelligent conversation about it, but this is what I think. To me, the explanation is to find why he isn't requiring her to absolutely be removed, even though he finds Wade has to be. Otherwise, finding Wade to be gone would require all gone. Well, no, only finding her to be gone would require everyone to be gone. Wade isn't the prosecutor, so that's not correct. So this doesn't flow. This does not flow. This conclusion does not flow from its premise. Yeah, this conclusion does not flow from its premise. And I don't know how I can explain it any better than that. I've given it 3 or 4 or 5 tries now to explain. So if I've continued to fail as a teacher, I don't know how I can better explain. I think the judge might be saying the whole of her office may choose to step aside. Well, the judge is saying that that's a requirement, right? Because you have 2 options. You have 2 options. The district attorney may choose to step aside along with the whole of her office. So her entire office is disqualified, or Wade can withdraw. So that doesn't work. It doesn't work. It doesn't follow. I didn't fail. I only failed in so much as I failed as a teacher, because I explained it and people said I don't get it. I explained it and people said I don't get it. And I explained it and people said I don't get it. It's like I'm only failing in so much as I'm not explaining myself. It's like one of 2 things is true. Either I'm confused or I'm failing to explain things. And I've read it and reread it and reread it. And I'm like, I don't know where I'm making a mistake, and I'm failing to convey what I'm trying to say, so I don't know where I'm failing. All right. So moving back to the issue of forensic disqualification, the court has not located nor been provided with a single additional case exploring the relevant standard for forensic misconduct, or an opinion that actually resulted in disqualification. So as Ms. Willis herself pointed out, this appears to have never actually been done. Left unexplored, therefore, is how other examples of forensic misconduct can manifest, such as whether statements that stop short of commenting on the guilt of the defendant can be disqualifying. Nor has it been decided if showing of prejudice is required, and how a trial court should go about determining whether prejudice exists. Nor is it clear whether the analysis differs depending on the pretrial posture of the case. Unmoored from precedent, the court feels confined to the boundaries of the relevant case law and restricts the application of fact here to its holding. The defendants have exhaustively documented every public comment made by the district attorney concerning this case through their motions and filing. Many of these have already been addressed through pre-trial challenge made on similar grounds brought by the defendant. The court incorporates and adopts the sound reasoning of a different judge and finds any comment made by the district attorney prior to July 31st, 2023 did not amount to disqualifying forensic misconduct. Public comments about the need for and importance of investigation fall short of the type of bias, explicit or implicit, that must be found. Similarly, more recent comments describing the change in the charges in the indictment, the procedural posture of the case, the office's conviction rates, and personnel behind the scenes anecdotes are not disqualifying. This includes the district attorney's unorthodox decision to make on-the-record comments and authorize her staff to do so, to authors' intent on publishing a book about the special grand jury's investigation during the pendency of the case. They're working on a book because, of course, they are. Such decisions may have ancillary prejudicial effects, yes, to be realized, but the comments do not rise to the level of disqualification. The same cannot be so easily said for the district attorney's prepared speech delivered before a congregation of a local church on January the 14th of 2024. In these public and televised comments, the district attorney complained that Fulton County Commissioner and so many others questioned her decision to hire Wade. When referring to her detractors throughout the speech, she frequently used the plural they. The state argues the speech was not aimed at any of the defendants in this case. Maybe so, maybe not. Therein lies the danger of public comments by a prosecuting attorney. By including reference to so many others on the heels of defendant's Roman's motion, which instigated the entire controversy, the district attorney left the question open to the public to consider. The court finds, after considering the statement as a whole, under the circumstances surrounding its issuance, that the district attorney's speech did include defendant Roman and his counsel within his ambit, whether intentional or not. More issue, instead of attributing to criticism to a criminal accused's general aversion to being convicted and facing a prison sentence, the district attorney ascribed the effort as motivated by playing the race card. She went on to frequently refer to Wade as the black man, while her other unchallenged SADAs were labeled one white woman and one white man. The effect of the speech was to casual racial aspersions as indicted defendant's decision to file the pretrial motion. However, the speech did not specifically mention any defendant by name. Although not improvised or inadvertent, it also did not address the merits of indirect offenses in an effort to move the trial itself to the court of public opinion, in order to disclose sensitive or confidential evidence yet to be revealed or admitted at trial. In addition, this case is far too removed from jury selection to establish permanent taint of the jury pool. As best as it can divine, under the sole direction of Williams, the court cannot find the speech cross the line to the point where defense had denied the opportunity for a fundamentally fair trial or that it requires the district attorney's disqualification. But it was still legally improper. Why should the judge have recused himself? Who would decide it other than the judge? That doesn't make sense. But it was still improper. Providing this type of public comment creates dangerous waters for a district attorney to further wade into. The time may well have arrived for an order preventing the state from mentioning the case in any public forum, to preventing prejudicial pretrial publicity. But that is not the motion before the court. So the judge is like, maybe a gag order, but that's not what we're doing right now. Defense motion demanding disqualification on forensic misconduct is denied. No surprise there. There appears to be no precedent in case law for such a thing, and they're not going to do it now. That makes fun. The defendants invoke a range of other constitutional, statutory, and county provisions in support of disqualification, including the Georgia Constitution, various provisions of the Fulton County Code, including financial disclosure requirements, and alleged payment and hiring violations pursuant to law. As to the latter, a district attorney may appoint private attorneys to assist in criminal cases independent of any specific authority. There's some case law on that point. The statute does not place limitations on the appointment of a special attorney to work on a specified case as opposed to a county approval of a general employee. While the contract did not limit work to any particular case, the testimony established as much, and defense have not produced any evidence demonstrating his work ever expended beyond this prosecution. Yeah, exactly, Looper. You think he'd explain why he chose entire office dismissal. That would be helpful. Like, why are you doing that, given your own premises? That would be helpful. Please explain to me. Also, I'm not even sure your premises are true. We still have to do that, and we will. We will go look up that case law. Because I'm not even sure the premises are true. So, we talked about that earlier. It's like, I'm not even sure the premises are true. But given your own premises, why are you following this conclusion? It doesn't flow. And we'll also read the case law to see whether or not the premise is correct. Because I have my doubts. Furthermore, to the extent the defense argued the circumstances of Wade's loyalty oath create independent grounds for disqualification, the court incorporates its previous order on the subject and denies the motion. As for remaining provisions and arguments, the court has not yet been presented with any authority that such violations, even if proven, amount to an actual conflict of interest, nor has any appearance of impropriety can apply to any instance of inappropriate or wrong behavior. I expect they'll appeal. I think so too, but we'll go look up the law to figure out what the chances are on appeal. You know, we'll figure it out. Because you do have a pure question of law, right? The judge made a whole bunch of factual findings and then reached a legal conclusion that seems at least questionable on the law. So yeah, we'll see. We'll read the cases and see what the judge's chances are on appeal. We'll see. In each case, applying the appearance standard, the impropriety was connected in some way to an allegation of a potential and previously recognized actual conflict. Pre-trial or post, I imagine they'll appeal right away. In a separate motion adopting the arguments of the co-defendant, Defendant Latham presents an additional theory. She asserts the right to call the district attorney as a witness at trial to examine her bias towards the defendant and demonstrate that she brought a politically motivated prosecution. Accepting the sole citation in support that allowed for impeachment of a prosecutor for improper motives or bias requires ignoring the opinion surrounding context. Actually reading the case and authority upon which it relies, and not simply quoting a head note, reveals the Court of Appeals anticipated the use of the word prosecutor, referred not to the legal officer handling the case, but rather to the main witness for the state. So they weren't talking about a prosecutor, they were using the language in a different sense. Defendant Latham asserts a claim accurately categorized as one of selective prosecution, and the United States Supreme Court has recognized that such claims are not a defense on the merits to any charges themselves. Instead, a claim of selective prosecution must be brought in a form of a motion, asking the trial court to exercise judicial power on equal protection grounds. Lacking such a showing here or any foundation, the motion is denied. All right. When the case ends in conviction, acquittals, or something in between, the result should be one that instills confidence. A reasonable observer, unburned by partisan blinders, should believe the law was impartially applied, that those accused of crimes had a fair opportunity to present defenses, and that any verdict was based on our criminal justice system's best efforts at ascertaining the truth. Any distraction that detracts from the goals, if remedial under law, should be proportionally addressed. After consideration of the record established on the motions, the court finds the allegations and evidence legally insufficient to support an actual finding of conflict of interest. However, the appearance of impropriety remains and must be handled as previously outlined. The motions are granted in part and denied in part. Okay. So all that makes sense except for the law, because that seems like an odd conclusion. I don't understand. I think the judge might be making shit up, which to be fair, maybe the judge is making shit up because the case law does seem to be a little thin on this issue. So maybe the judge is making shit up, but that's okay. Someone has to. Let us go read this case in this paragraph about this disqualification thing, because I don't think the judge, I'm not sure in the precedent. I'm not sure the judge is citing the precedent correctly. And the judge is definitely not applying it correctly because we pointed out the inherent contradiction. But I'm not even sure the precedent says what it says. So let's find out if the precedent says what it says. That will be a fun exercise. as we try to judge the likely options on appeal. So let's go read this and see if it says what it says it says. I have to find the citations. Okay. So we have these two citations. Well, we have three. We have this case McLaughlin versus Payne. We have this case Head. And then we have this case Frazier. All right, let's go do some case law research. They say they didn't address appearance standard and made a point to limit disqualification to an instance of absolute disqualification. Is absolute disqualification a thing? I have my doubts. Will more evidence come in an appeal, or are they all in the briefs anyway? As to what? As to this issue? Oh no, they can't bring in more evidence. No, I mean there was a hearing. You can't bring in more evidence in appeal. Can't do that. Oh, we don't have Zelle anymore. I need to update the box. Or I need to put it in for Cash App. I need to update that thing. Please, Tony, would you make a note in the YouTube mod chat and in Discord reminding me to update the trigger for the donate thing? The appeal court can't dig into the cell phone briefs? I have no idea what you're talking about. As to where their locations were and stuff like that? No, the judge didn't use it as a statement of fact. So the judge is entitled to the facts that they believe and stuff. And so, and also it's not the judge, yeah, no, not really. The judge made their rulings on the issue and decided that was apparently unable or unwilling to reach certain conclusions with respect to the cell phone data. So no. That's a question of fact in this context. I don't see. If it's still the case that was overturned on these laws, would it likely be in favor of the prosecutor? That's my gut. That if we overturned it, it would be in favor of the prosecutor. But we're going to find out. We're going to go read some case law together. We're going to do a deep dive together. So strap in, people. We're going to be here for a second. As we try to understand what the case law cites, because the court cited 3 cases for this very weird proposition. All right, let's see what we got. Can she still get disbarred? Yes, the bar could still take cases, still take action against. Can they appeal insufficient time for evidence? No, it doesn't appear that was a factor. The judge is in control of the courtroom and is allowed to set reasonable time frames, and it doesn't seem like the standard would be abuse of discretion at that point. The standard would be abuse of discretion, that the judge abused discretion by the time frames they chose, and I don't think that. Why can't the GBI request messages? Who says they can't? They can to the extent that they have cause to. The Georgia Bureau of Investigation is law enforcement, so they can get data to the extent it would be relevant to a criminal inquiry. So they could get a warrant. Bar won't do squat. I think you're probably right. All right, let's read this thing. All right, so we got a guy who's convicted of child bad stuff. At the trial, the district attorney appeared as a witness for the state. Okay, that's odd. He identified himself as the district attorney, identified the examining attorney as his assistant, outlined his duties as attorney. The district attorney was a witness in the case. That sounds like one hell of a conflict. He also testified that his daughter was a classmate of the victim named indictment. His daughter told him what he had heard during it, blah, 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 blah. On appeal, the defendant contended that he was not present at all stages of the trial. Venue was not proven. Evidence of a prior similar transaction was wrongly admitted, and counsel was ineffective to objecting. His convictions were affirmed by the Court of Appeals, or affirmed actually by the Georgia Supreme Court. He files a writ of habeas corpus, raising a claim of ineffective assistance counsel. After multiple hearings, the habeas court found that the prosecutor had a conflict of interest, had testified falsely at trial, and appellate counsel should have pursued these issues on appeal. So he's raising ineffective assistance of counsel for his appellate attorney. Habeas court also found that the issue had been raised on appeal. The result would have been different. Consequently, the court granted the writ. The warden contends that the habeas court erred in finding the representation was ineffective, speaking to effective assistance of counsel. Prior to trial, Payne filed a motion to disqualify from acting on the case, citing the designation as a witness, and urged that the required dismissal of the entire office, and citing a relevant rule. The principle that a lawyer is to avoid testifying in a case in which he's actually an advocate is long-standing, no doubt, formally codified in law, which reads that when a lawyer is a witness for his client, except as to merely a formal matter, such as the attestation or custody of instruments and the like, he should leave the trial of the case to other counsel. Except when essential to the ends of justice, a lawyer should avoid testifying in a court on behalf of his client. That makes sense. It has long been recognized that if an attorney will appear as a necessary witness, disqualification of the attorney is appropriate. The court has observed that whereas a conflict of interest in a counsel dual role as advocate and witness, an attorney to act as both witness and advocate is a circumstance to be avoided. The practice of trial attorneys testifying is not approved by the courts except where made necessary. So we're trying very much to avoid. While these considerations would preclude McDade acting as an advocate for the state before the jury, they do not address the issue of whether his disqualification as trial counsel as a consequence of his role should have been imputed to his entire staff. $10 from Kumar 01234. That's the code on my luggage. What's my take on Judge McAfee? Do you think it hurts his election bid for a full 4 years? Or is that position uncontested position? I don't know. I don't take any immediate position on that issue. My questions are one of law. I want to come up with the right legal conclusion. So what it will do to his political positions are not my immediate concern. My immediate concern is whether or not he's correct on the law. So I will confine my analysis to that, but I appreciate your question. Thank you very much for your super chat and for your support of the channel. Just a friendly reminder, of course, that I am, of course, completely supported by you, the viewer. So your support is appreciated. And for those of you who have Amazon Prime, you can, of course, subscribe to me on Twitch, which pays me money but does not cost you anything. So if you'd like to subscribe on Twitch, hit the command !Twitch, and it will give you the instructions of how to do that, and also set up a calendar reminder because you do have to renew it manually every month. And we do appreciate it. Jeff Bezos gives me money. You don't give me money. Everyone is happier. Yeah, thanks for keeping a topic on law, not politics. I always aim to answer these questions within the confines of law as best as I can. So it's like, I don't really like to do politics. It's not what I do. You're welcome. All right. While these considerations were precluded, it does not answer whether it disqualifies his entire staff. When an attorney is precluded from acting as an advocate under the rule because he's a necessary witness, his status is not automatically imputed to other witnesses in his office, although circumstances may leave other attorneys with their own disqualification. A lawyer may act as an advocate in a trial in which another lawyer in his firm is likely to be called as a witness, unless precluded from doing so by relevant law. And the precedent of this court does not require that McDade's role as a witness disqualify all those in his staff. In order to deny the motion to disqualify the entire district attorney's office, based on the prosecutor's disqualification, the trial court relied on a case called Brown v. State. As to the issue of the district attorney serving as a witness, the court noted, the trial court did not err by denying the motion to recuse the entire office simply because the district attorney himself, who was a witness, was disqualified. Okay. When considering a claim of ineffective assistance of counsel, the reasonableness of counsel's performance is judged from counsel's perspective at the time. Failure to argue an issue contrary to prevailing law would be ineffective assistance of counsel only in a rare case. Appellee's counsel failure to raise on appeal any issue regarding McDade's preclusion from serving as an advocate being imputed to the remainder of his office could not serve as a basis for finding of ineffective assistance of counsel. Nonetheless, the habeas court found that McDade had a personal interest in the case that disqualified him from proceeding in the prosecution of the case at all, not from just serving as trial counsel. So we have another problem other than him being a witness to the case. We have another thing, so that's a problem. And this finding does raise an issue implicating not only McDade's role in the prosecution, but that of the entire office. The elected district attorney is not merely any prosecuting attorney. He is a constitutional officer, and as such, there's only one such officer in each circuit. He is the executive branch unto himself for the purposes of the prosecution. Under our state constitution, it shall be the duty of the district attorney to represent the state in all criminal cases in superior court of such district attorney's circuit. The elected district attorney appoints assistant district attorneys. The assistant district attorneys serve only at the pleasure of the district attorney, and their authority is derived from them by necessity. They are but fractions of his power. In a Georgia criminal prosecution, the whole proceeding from the time the case is laid before the district attorney until rendition of the verdict is under the direction, supervision, and control of the officer, subject to restriction of law. Counsel employed to assist the prosecution can perform no duties except those that the district attorney allows them to perform. They can do anything that the district attorney can do, but only if the district attorney allows them to. And no more, because the district attorney can give no more authority than he had in the first place. Or she had in this case. The court has recognized that a district attorney is of counsel in all criminal cases or pending matters in his circuit. This includes investigation steps of matters preparatory to seeking indictment. So they are district attorney no matter what. And for a prosecutor to have a conflict in cases contrary to public policy and can warrant a new trial. When the enlisted district attorney is wholly disqualified from a case, the assistant district attorneys, whose power in the case derives from their authority of the district attorney, have no authority to proceed. I mean, that's what I would think. While the statutory law permits the chief assistant district attorney to temporarily accept powers and duties of the elected district attorney, in the event the elected district attorney is physically disabled, mentally disabled, or temporarily absent, so, if they can't be a prosecutor because they're not there or whatever, then, fine. In the event that the elected district attorney is wholly disqualified, the statute contemplates something else under the relevant law. When the district attorney's office is disqualified from interest, excuse me, Yeah, Tony's right. Let's try to focus on the deep dive. We are, of course, a legal education channel, and we want to apply the law evenly and neutrally, as Lady Justice herself demands. As I put on my role as hypothetical judge, I put on my blinders and try to weigh in a non-political way. My personal feelings are neither here nor there, and if we want to be good legal thinkers, we must think in a neutral way and try to be even as best as we're able. So let's try to focus on the deep dive and try to figure out whether the judge is getting the law right. That's a good thing. Did the judge make a mistake? Let's find out. Okay, when a district attorney office is disqualified for interest in prosecution, they shall notify the AG and blah, blah, blah. And it's uncontroverted that no appointment or designation was made in this case. The habeas court finding that McDade had a personal interest in the prosecution was supported by the record. As the habeas court noted, McDade testified before the jury that the conversation with his daughter was very troubling, and the daughter's conversation with the victim was emotional. McDade described the relationship with his daughter as very close, emotional person, blah, 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 blah. We're talking about McDade's relationship with his daughter, because, so forth and so on. Okay, the assistant district attorney did so under the authority of the district attorney, because of course they did. And then they say they did not err in finding that the district attorney had disqualifying conflict of interest in the prosecution because they had acquired a personal interest or stake in the conviction. And then they say, as noted, the district attorney who acted in trial did so under the authority of the district attorney. This qualification removed that authority was not replaced pursuant to statute. As far as the opinion shows, the case involved an elected district attorney unable to serve as advocate because he was appearing as a witness. It did not involve the elected district attorney who was absolutely disqualified from any involvement in the prosecution because he had a personal conflict of interest. Yeah, so absolute disqualification is not a thing. It's like, or like, it's a very narrow thing. And so it's the court is overreading it, right? So there's a difference between the lawyer merely being a witness, which apparently does not require disqualification of the entire office, and the lawyer having a conflict of interest because of reasons, and therefore it's an absolute disqualification. So when the judge wrote in their thing, they write about the district attorney being absolutely disqualified, therefore the district attorney lacked any authority to proceed. McLaughlin did not address an appearance standard, which I suppose is true. It didn't make a point to limit total disqualifications to instance of absolute disqualification. I suppose is also true. So let's assume for the moment that this is so, but that was a case of the prosecutor being a witness, which is not the situation here. So so that is not really on point. So I question the applicability of this case to the facts at hand, because that situation isn't this situation. So I don't really buy the application of this case, but let's assume for a moment that there is a difference. So let's assume that there is a difference for the moment and press on. When the appearance conflicts, only the affected prosecutor, be the elected, is affected. And then they cite this case from the Georgia Court of Appeals, which I'm pretty sure does not actually say that. And I need the full citation so I can look it up. So let me just find that real fast. Find Alt F, find Alt F, edit, find. There it is. Let's go read this case together. Come on. There you go. All right, let's go read this case together. Give me a second to pull that up. I'm pretty sure what this case says. It's talking about a district attorney, not the district attorney. So I'm pretty sure this case is not speaking about the district. I base that on the quotation from the case. So I think the judge is misreading and misapplying this too. But let's find out. Why guess when you can go look? All right. We turn our attention to the case of Head versus State, Court of Appeals, 2002. All right, what we got? We got guilty of false imprisonment, violently assaulted his wife, erroneously denied his motion for a mistrial from the state, gave improperly bolstering statements. So we got some bolstering statements, blah, blah, blah. A mistrial under those circumstances is not mandated. Fine, blah, blah, blah. Denying the motion to disqualify the district attorney and the staff from prosecution. All right. The defendant moved for disqualification on the basis that the chief investigator in the district attorney's office dated and subsequently married the victim in this case. That's a lot. I mean, yeah, that's a lot. I mean, why do we want to disqualify the chief investigator? The chief investigator dated and married the victim. Well, that's a thing. Okay. Evidence was presented at the hearing on the motion that the chief investigator, a former police officer employed by the district attorney to conduct and supervise criminal investigation, met the victim in a social setting unrelated to the case. Oh, did they? Okay. The investigator told the victim where he worked, and the victim revealed she had a pending case. The victim's case was being handled by another investigator at the time, and the chief investigator was not personally aware of the case, which was one of thousands handled every year by the office. Before dating the victim, the investigator told the district attorney about the victim's pending case and asked if there was any problem in dating her. The district attorney responded there'd be no problem as long as the investigator had no involvement in the case. Thereafter, the investigator did not personally investigate the case, did not discuss the case with other investigators or prosecutors, and took no part in the decision of the prosecutors to indict. The investigator said his only contact with the case was while sitting out socially one evening with the victim, and she saw a man who she thought might have had some information about the case. The investigator testified that he spoke briefly with a man who said he knew the victim but had no information about the case. The defendant contends the investigator's close personal relationship with the victim disqualifies the district attorney and every prosecutor. Well, that doesn't necessarily flow, although he is the chief investigator, something. Then they say it's possible for a disqualifying conflict of interest to arrive when a prosecutor has acquired a personal interest or stake in defendant's conviction. For example, a prosecutor's close personal relationship with the victim in a case may at least create the appearance of prosecutional unfairness based on private interests rather than one properly based on vindication of public interests. Okay, so they are citing it properly. All right, okay. I stand corrected. The judge is reading it fairly. So the judge says, for example, in the prior case in 2002, for example, a prosecutor's close personal relationship with the victim in this case may create at least the appearance of a prosecution unfairness based on private interest rather than unfairness. The Court of Appeals says, in that case, the individual prosecutor who has the conflict may be disqualified, but not all other prosecutors will work for him. Okay, fair enough. Let's go read the Georgia Supreme Court to see if that's what they said. So it looks like the judge is quoting the law, although his propositions still don't flow from their premise, if that's true. We turn our attention now to Frazier versus States, 1987, Georgia Supreme Court. By the way, not for nothing, this is how lawyers do cases and how you should do cases, right? This is how lawyers roll. You read cases, they cite cases, you read cases, they cite cases, you read cases, you cite cases, right? Because you're trying to get down to ground. Unbreaded. So that's the role. This is what being a lawyer looks like in a lot of parts. This is what being a lawyer looks like. Reading cases, thinking, reading cases, thinking. All right. Let's see. So the case deals with a person named Frazier who's convicted of 2 counts of murder. Blah, 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 blah. Okay. Grand jury. Blah, blah, blah. Potential jury. Some other stuff. Dying motion to declare procedures. Not error to try the issues of guilt and sentence before the same jury. Appellant demurred to the indictment of the ground did not specify malice, so they're complaining about many things in the case, as one would expect. Appellant filed a plea for a misdemeanor, arguing he had never been known as Frazier. It was not his true name. His true name was Leonard Fraser. Yeah. At a hearing on a motion, we have documents signed as Frazier, and he was known as Frazier. The defendant may be indicted properly under a name by which he's generally known and called, whether it be his true name or not. Fair enough, because, we can indict someone by their street name, for example, if we don't know who they are yet. So yeah, if we can, as long as we can identify you, any name will do. So you want to be something other than your name, that's fine by us, as long as we can tell the difference, or we can figure out who it is. Co-defendant pled guilty, originally wanted 2 attorneys appointed. Some more stuff. Then we have, an attorney who was originally appointed to represent a co-defendant. Then that attorney was hired by the prosecution's office at some point. So we have an attorney representing a co-defendant who at some point becomes an employee of the prosecutor. No problem there. Because you can't change roles in the same case, which is true. And so they talk about that for a while, but there's no problem there. That's fine. Exercise preemptory challenges, that's fine. Voir dire, that's fine. What part of the case do they actually get to the thing? They gave me a string cite. 693, 695. Okay. Really? So I missed it? $693, $695. Okay. Well, let's go read those more carefully. All right. Apparently, this is the part of the case that matters. 693. Gave me a string cite because you go look up the right. You go look at the citation. Right. It says C. Frazier versus State, and then they give you the number 257 Georgia 690. 690 is the first page it appears, and then they give you a pinpoint site 693 to 695. So they're telling you 693 to 695 is where you need to go look for this. So this is page 693, you know, because it says it right there. A defendant may be indicted under a name in which she's generally known and whether this is true name. If Frazier is not appellant's true name, it's clear in what she's generally known. We find no error in denial of plea. Appellant's co-defendant, Jim Asher, pled guilty prior to the trial. In return for state's promise not to seek the death sentence, Asher agreed to testify at this guy's trial and provide the state with an investigative file compiled by the court-funded private investigator. Okay. This guy contends that providing the state with the investigative file violated attorney-client privilege. Okay, so what happened here? All right, so Asher is a co-defendant in this murder trial. Okay, he's entitled to an attorney. In addition to being appointed an attorney, he is also appointed an investigator. That's what it says, right? He's appointed a court-funded investigator. So in addition to the attorney, he's also funded with a PI. Okay? So in return for the state's promise not to seek the death sentence, Asher, his co-defendant, agrees to testify at his trial and to provide the state with the investigative file that was compiled by his court-appointed investigator. Which sounds okay to me because it's his investigator, right? It's his privilege, so it sounds okay. This guy, who's not so happy about it, contends that providing the state with the investigative file violates his attorney-client privilege. How? However, Asher's investigative file contains no confidential communications between the appellant and his attorney, nor any work product. Hence, none of the material disclosed is encompassed by privilege, and the appellant may not invoke another privilege, even if the other is his co-defendant. Yeah, you can't invoke his privilege. You can't invoke someone else's privilege. So there's nothing in here about your privilege. There's a lot of things in here about his privilege, but that you can't invoke his rights. Okay, then they talk about, that's fine. They talk about this attorney. Attorney Ronald Silvey was originally one of two appointees appointed to represent the co-defendant Asher, while attorney Ken Poston was one of two attorneys appointed to represent the appellant. So they have different attorneys representing them. Cool. Silvey represents Asher. Cool. Silvey represented Asher for 2 weeks in 1986 and then was relieved of the appointment when Silvey's law firm hired David Dunn, who until then had been employed as an assistant district attorney. Okay, so I misunderstood it. It wasn't that he was hired as the district attorney, they hired someone else from the district attorney's office. So Silvey's law firm hires David Dunn, who was, up until that moment, an assistant district attorney. Okay. That Poston represented appellant for almost a month and was removed from the case in 1986. Okay, fine. So he appointed him, they hired someone from the prosecutor's office, and then there was a disqualification. Okay. Or he's removed, whatever. The case was tried in 1987. Prior to the court's disposition, Poston was hired and Dunn was relieved by a district attorney's office. So prior to the motion for the new trial, this hiring thing took place. The appellant filed pre- and post-trial motions to disqualify the district attorney and staff from prosecuting on conflict of interest grounds. Here, the trial court erred by overruling. The court writes, there's no issue here about the propriety of any involvement by Poston or Dunn at the trial or at any post-conviction proceedings in this case. It would be improper for an attorney to change roles from prosecution to defense in the same case. You can't do that. You can't switch sides in the same case. That is definitely a no-no. Quite properly, neither Dunn nor his firm participated in the defense of this case after Dunn left the district attorney's office. So, by hiring an assistant district attorney, you have disqualified your office. Okay, fine. That makes sense to me. I'm not sure that's necessarily required, but that's what happened. Nor has Dunn or Poston participated directly or indirectly in the prosecution of this case since joining the office after the attorney's case was hired. So, yeah, they didn't have anything to do with anything. That makes sense. All right. Appellant argues, however, that because Dunn and his district attorney reached some agreement prior to the trial that Dunn would rejoin the office at some future date. Okay. And because Dunn and Poston did join the district attorneys after the trial, but while the post-trial proceedings were pending, the entire district attorney's office should have been disqualified. Okay, so this guy who worked for the district attorney's office was hired by a law firm, and then at some point was hired back by the district attorney's office. So, you know, there's maybe an imputation now the other way. So this apparently happened after the trial, but post-trial proceedings were pending. Okay. So he argues that requires the entire district attorney's office should have been disqualified, which doesn't sound right to me. On the theory that a district attorney's office is like a law firm, and where one member of a firm is disqualified, all members should be. Okay. It is true that the relevant rule states if a lawyer is required to decline employment or to withdraw under a relevant rule, no partner or associate of his or her firm may continue or accept such representation. So if it's a private firm, then it does dismiss the entire office. However, a majority of jurisdictions addressing this issue have concluded the Code of Professional Responsibility was intended to provide a distinction between private law firms and the government. The imputed disqualification rule is not meant to encompass government offices. So does this cover the government or not? And a majority of jurisdictions say no, it does not, which makes sense because that's why we talk about Chinese walls and walled gardens and everything else. As the ABA, which I'll remind you has no actual authority, but they like to pretend they do. As the ABA explained in a formal opinion, the salaried government employee does not have a financial interest in the success of departmental representation that's inherent in private practice. Well, that's not necessarily inherent either, by the way, as to the entire office, but let's press on. This important difference in the adversarial posture of government lawyers recognized by Canon 7. The duty of the public prosecutor to seek justice, not merely convict, and the duty of all government lawyers to seek just results rather than results desired by the client. The channeling of advocacy towards a just result as opposed to vindication of a particular claims lessens the temptation to circumvent the rules through the action of associates. Accordingly, we construe the relevant rule to be inapplicable to other government lawyers associated with a particular government lawyer who himself is disqualified pursuant to these relevant rules or similar rules. Although vicarious disqualification, which is just what it's called when we impute me, right? He knows me, there he knows you. What's the song? Mr. Hank me, the Christmas poo. He loves me, I love you. Therefore, vicariously, he loves you, even if he's a poo. Right? So the transmutation of, you know, ideas. All right. That's vicariously. The individual lawyer should be screened, segmented, walled garden, Chinese wall, from any direct or indirect participation in the matter, and discussion with colleagues concerning these relevant is prohibited. The relevant law does not hold to the contrary. Their district attorney was disqualified from prosecuting the case. Although he did not try the case himself, he was present in the state's trial. The active participation was improper. Davenport does not hold the entire office was disqualified. So they're citing a case that's citing a case. We might have to go read Davenport. The district attorney disqualified. The active participation was improper. Davenport does, although he did not try the case himself, he was present at the state's table. This active participation was improper. Davenport does not hold that the entire office was disqualified. So that's the proposition that we can disqualify the district attorney without disqualifying the office. So I suppose we have to go read Davenport now. I guess. Not that it really matters because the Georgia Supreme Court citing it with approval, and that's probably enough. But let's go cite it anyway. All right, we need to go read Davenport at 7:04 with no pinpoint cite. That's great. Thanks, Court. I really appreciate that. Thanks for giving me a case without a pinpoint cite. That's fantastic. All right, so let's see. Procedural history, blah, blah, blah. Deny due process because Appellant in that case contends that they were denied due process law because the district attorney prosecuting the case had represented the victim in divorce proceedings before the appellant and the victim. Nice. That's a fun conflict of interest. What is the conflict of interest? I can't help noticing that the district attorney represented my spouse in our divorce. That's fun. That's fun. Can't help noticing the district attorney represented my spouse in our divorce. Yeah. Who, by the way, is who is now the victim in this case. Yeah, that's great. The district attorney represented my spouse in our divorce, and my spouse is now the victim in this criminal case. Okay, that's a thing that happened. The divorce action was filed prior to the indictment, one would hope, which resulted in the indictment against appellant for aggravated assault. Wow. Okay. So the divorce case itself spurned on the criminal case. That's a lot. So the district attorney I don't know if the district attorney is moonlighting as a divorce lawyer. I'm not exactly sure what's going on here. I'm not sure if the district attorney is moonlighting or what's going on. But the district attorney is representing the wife in a divorce. The divorce action was filed prior to the incident. Oh, so it's not emerging from the thing. It's separate from the thing. So the divorce action was filed prior to whatever caused the criminal thing. Okay. I thought it spurned off. It was even weirder. All right. The appellant filed for divorce in 1975. Robert Keller, who was engaged in the private practice of law, was retained by the wife to represent him in the divorce proceeding. The divorce action was pending in the Superior Court of Clayton County from 1975 until 1978. Meanwhile, while the divorce is underway, he is appointed the district attorney of the circuit. Super. And on October the 13th of 1978, Robert Keller's name was withdrawn as an attorney of record from the divorce action. I'm sure we all feel well better. So in July, that's great. So on July the 1st of 1977, while the divorce is pending, the defense lawyer for the woman becomes the district attorney, but he didn't stop being her divorce lawyer until like 15 months later. So for 15 months later, he was both the wife's for 15 months, he was both the wife's divorce lawyer and the elected prosecutor of the county. Super duper. In 1976, which is after the filing of the divorce, but still well before the divorce was finalized and still before the prosecutor removed himself in 1978, in 1976, the husband apologized. The appellant, wait, am I reading this correctly? What is going on in this case? This is fun. What the hell is going on in this case? All right. In 1976, the appellant shot Mr. Davenport, who then took out a warrant against Mrs. Davenport. That doesn't sound right. That sounds backwards. Appellant was indicted for aggravated assault. The appellant shot Mr. Who's the appellant? Is it Mrs. Davenport? Hold on. It's Martha Davenport. So Martha Davenport is the woman. Okay. So wait, she had represented herself. Okay. So the prosecutor had represented her. in the divorce proceedings. No, wait. Oh, between the appellant and the victim. Okay. It was just sloppily worded, and I was confused. Okay, so we have to revise. Okay, so he was the divorce lawyer for her, and then prosecuted her. Okay, at the same time, which I'm not sure which is worse, by the way. But let's correct the record. He was the divorce lawyer for her, and then prosecuted her. At the same time, he was also the divorce lawyer for her. So that I'm not sure which of these scenarios is worse, but now we've corrected the record because now we understand who's who. All right. So in 1976, which he became district attorney in 1978. In 1976, the wife shot the man, who then took out a warrant against the wife. The wife was indicted for aggravated assault in 1976 while someone else was the district attorney. The wife was arraigned in 1977, over a year after the indictment had been returned, and subsequent to the appointment of her own attorney as the district attorney. So she is arraigned at a time that her own divorce lawyer is now prosecuting her. Exciting and fun. Yeah, exciting and fun. Exciting and fun. All right. The wife pled not guilty, and the plea was signed by Keller, who is her lawyer in the divorce case. Although an assistant district attorney happened all pre-trial motions and the actual trial, Mr. Keller, her lawyer / prosecutor, was at counsel's table during the trial. Okay, that's a thing. The state contends this issue raised by appellant regarding Mr. Keller's role in the prosecution was decided adversely to appellant. We do not agree. The trial court granted a writ of habeas corpus and a new trial on the basis of the appellant having been denied the right of appeal. The state appealed that order, and the Supreme Court held that only that because appellant had been denied adequate assistance of counsel on the appeal of conviction, she was entitled to an out-of-time appeal. So we said nothing about trial counsel. We only said things about appellate counsel. All right. Prior to trial, the wife, objected by motion to her own attorney's role in the prosecution of the case against her. You know, I'm not really thrilled with my own attorney prosecuting me. That does not please me. While we do not believe that Mr. Keller, my attorney, would act intentionally in a manner that would prejudice a criminal case, we are constrained to hold that he should not have participated in any way in the prosecution of the case. You think? You think maybe that would be a problem? Maybe he shouldn't participate in the prosecution of his own client. Maybe that's a problem. Okay. Under such circumstances, there's at least an appearance of impropriety. You think? And we must conclude the appellant, the wife, was denied fundamental fairness in the state's prosecution of charges. The administration of law, and especially that of criminal law, should be like Caesar's life, be above suspicion, should be free from all temptation, bias, or prejudice, so far as is possible for our court to accomplish. And also, he's still her divorce lawyer the whole time. This is amazing, right? Because it wasn't until October 1978 that he was withdrawn as the defense attorney, or he was withdrawn as the divorce attorney. So until October 1978, he's still her divorce lawyer. So in 1977, he's still her divorce lawyer, and the prosecutor all at the same time. That's fun. All right, where were we? It is clear that he was cognizant of information and incidents that occurred between the victim and the woman by virtue of the fact that he represented. Wait, no, it's Mr. Davenport in the divorce proceedings. Now I'm back confused again. Who's who? So he represented Mr. Davenport in the divorce. I'm confused. Who's representing who? He's the guy's lawyer? I was right the first time? I'm confused. I'm so sorry. The appellant filed for divorce. The appellant is the woman from Harold. Robert Keller, who was engaged in private practice, was retained by Mrs. Davenport to represent him in the divorce proceedings. You mean Mr. Davenport. That's why you confused me. You said Mrs. and you meant Mr. I hate you. I hate you. Retained by Mrs. Davenport to represent him in the divorce proceedings. So I read Mrs. Davenport and thought it was her. I hate you. I hate you for your typo. This is not entirely my fault. I'd like to take note for the record. I only accept partial responsibility for this bullshit. All right, let's go wipe our minds once again and return to a new and exciting reality. All right. He represents the husband in the divorce proceedings. The wife shot the husband. He's prosecuting the wife. It's not her attorney. It's the husband's attorney. Moving on. It's real, it's not for nothing. It's really hard to be a good teacher when the thing I'm teaching against is confusing me. Anywho, prior to trial, Mr. the husband objected to the appellant. That's the wife. Prior to trial, the wife objected to a motion to Mr. Keller's role in the prosecution of the case against her. While we do not believe Mr. Keller would act intentionally in a manner that would prejudice the wife's case prosecuted by his office, we're constrained to hold that he should not participate in any way in the prosecution of the case against the wife. It is clear that he was cognizant of information and incidents that occurred between the husband and the wife by virtue of his representation of the husband in the divorce proceedings. The husband in the divorce proceedings. Under such circumstances, there's at least an appearance of impropriety and must conclude that they were denied fundamental fairness. The administration, all these pronouns also don't help. When they keep talking about the victim and the appellant, all the pronouns don't help because it doesn't help to relate to who's who. I blame pronouns. This is pronouns problems. Names would help a lot. Although they have the same name, so we might refer to them by first name, but whatever. The problem with pronouns, who the hell are we talking about? In our opinion, public policy prohibits district attorney from prosecuting case, even though he does not actually try the case himself, while representing the husband of the case in a divorce proceeding involving the wife who is being prosecuted. Okay, great. Yeah, he went into a coma and 10 years later. Yeah, this is some soap opera shit right about now. That's true. We're in General Hospital and we're having a bad episode of, is this a dream? Is this a dream? Is this a fantasy? Is this really happening? Is it not really happening? This is some bad soap opera shit. This is not my fault. In enumerations 5 and 6, the appellant contends that the trial court erred by refusing to admit defense evidence of the victim's prior acts of violence toward the appellant. On cross-examination, the appellant's daughter, a state witness, was asked if she ever seen her father hit her mother. The court sustained the state's objection and further would not permit appellant to testify to acts of violence by Mr. Davenport against her. Okay. Yeah. The general rule is where the accused is on trial for assaulting and injuring or killing the victim, evidence of prior difficulties between the parties may be shown if there's such as a tendency to throw light on the transaction at issue. By transaction here, they mean criminal transaction. They mean the crime or the series of related crimes. Prior threats may be shown as bearing on the question of whether the defendant acted in self-defense. Fair enough. If previous difficulties are such as to shed light upon motive, they are competent evidence. Testimonies of specific prior acts on part of the victim towards the defendant are generally inadmissible, unless they tend to support the self-defense theory, as prior threats towards the assailant on part of the assailed or transactions sufficiently connected with the event to show light on it. We're talking about criminal transactions, right? So again, we're talking about closely related in time or purpose. So we don't typically allow for specific prior acts unless they are sufficiently related to the criminal transaction to be, in some sense, causally tied. So, we don't allow other things, generally speaking. If prior transactions, and not for nothing, but because I know what they mean by transaction, they mean criminal transaction, but it's not very helpful to you, the reader. Because when you read transaction, you think, oh, you mean like buying and selling stuff. That's a transaction, right? You go to the store and you pay for something. That's a transaction. So they're talking about transactions, and you're thinking to yourself, what does this have to do with buying and selling? And it doesn't. They mean criminal transaction. They mean the crime or set of crimes that are closely related in time and or purpose, that can be said in some sense to be part of a contemporaneous whole rather than individual crimes that should be tried separately. That's what they mean by transaction. It's a term of art. Moving on. If prior transactions are too remote, either in time or context, closely related in time or purpose, that's what I just said. So if they're too remote in time or purpose, the court may allow examination to be curtailed. Fair enough. Appellant admitted to shooting the victim, but testified she had done so in self-defense. There's also evidence on both sides that there have been other belligerent confrontations between the victim and the questions regarding the victim. In our view, it's not necessary to address remaining error. Okay. So we do get the idea that there's only an appearance of impropriety, not an actual conflict. And then they say, public policy prohibits a district attorney from prosecuting the case, even though he does not actually try the case himself while representing a victim of the alleged criminal in the accused. And they're entitled to a new trial based on this enumeration of error. But the court doesn't actually say whether or not the entire office has to be disqualified or not. They just simply say, this was wrong, go back and try again. Right? They don't actually say at any point that, well, they say that the prosecutor had to be disqualified. I mean, that much is clear. But they don't actually say at any point what that means for everyone else in the office. Right? They just simply say, all they say is, public policy prohibits a district attorney from prosecuting a case, even though he doesn't actually try the case himself while representing the victim. So he's prohibited from prosecuting, but it doesn't actually say what's true of everyone else in the office. So this is like bad game of telephone over here, which sometimes happens in law. So then they cite this. So then the Georgia Supreme Court, citing this case in essentially dicta, says Davenport does not hold the entire office was disqualified. No, it doesn't hold that, but it didn't also not hold that. It didn't actually say either way. It was silent on the issue. So the Supreme Court, citing this Georgia appellate court, says correctly that Davenport does not hold the entire office was disqualified, but also doesn't say the opposite of that. And then also, incidentally, in this case, they are talking about, are they talking about an actual conflict of interest or a perception of conflict of interest? So let's see. So they talk about the rule. They talk about the rule about disqualification. They talk about the rule. We find no misconduct in the trial court's application of the motion. Disqualify the district attorney and all their staff. A denial of the motion because it's only a guy. It's only a guy. It's not the district attorney, right? It's only a guy, so we can segment it off. So fine, we can segment it off. We can do our Chinese wall thing because it's not the district attorney. But they have this kind of throwaway line where they say a district attorney was disqualified from prosecuting the case. Although he did not try the case himself, he was present at the state's table. This active participation was improper. Davenport does not hold the entire office was disqualified. Although it doesn't hold the contrary of that. And even if it did, you're the Supreme Court of Georgia, so who cares? But this is now law, right? So the court says active participation is improper. So the Georgia Supreme Court has somewhat potentially unintentionally led to the possibility that yes, you can disqualify the prosecutor without disqualifying the entire office based on a bad game of telephone in a throwaway line in a case. But that's sometimes what happens, right? And especially if you're an attorney, right? You sometimes are left with a throwaway line and you're like, well, that's the thing now, right? That's the thing. And the Georgia Supreme Court said it. So, I mean, there is that. So, I mean, you got that going for you. And then you talk about this case, which talks about a prosecutor acquiring a personal stake, and the individual prosecutor may be disqualified, but you're not talking about the prosecutor in this case. And then you go back to, so now with all that deep dive, now that we've done an incredibly deep dive on this, we can now comment intelligently, you and I, about what the judge ruled as we think about appeal. I'm sorry we had to go through 5 different cases to figure it out, but sometimes that's what you have to do. You have to go through 5 different cases to figure it out. Welcome to law. Sometimes it's not easy, guys. Sometimes it takes an hour. You know, sometimes it takes reading 5 cases. One of the reasons that attorney bills can sometimes be pretty expensive because sometimes it requires reading things. Requires reading things, figure out what's really going on. All right, now that we've done that deep dive, let's read back what the judge wrote and comment in a more intelligent manner. The court writes in the Fani Willis case, nor would the finding of an appearance of impropriety on the part of the district attorney itself, in contrast to an actual conflict, necessarily result in the disqualification of the entire conflict. Entire office. The district attorney McLaughlin was absolutely disqualified due to personal interest. As a result, the assistant district attorneys lacked any authority to proceed. Distinguishing, McLaughlin did not address the appearance standard and made a point to limit disqualification to an instance of absolute disqualification. Okay. Where the appearance of conflict exists, only the affected prosecutor, be the elected or appointed, is affected. Citing Head, which is not good authority in my opinion for this proposition. Citing Frazier versus State, which is good authority for this proposition. Stating that in an appearance of impropriety case, by knowing the district attorney's disqualification did not result disqualification of the entire office. So fair enough. So you have correctly understood the precedent, and now I'm just confused with your conclusion. Or you've arguably correctly understood the precedent. There are other interpretations, such as it's dicta, such as it's best ignored, such as whatever, right? But we're going to take it at face value, which, you know, is definitely a thing we can do. Potentially because we want to, potentially because we're desperate to find something, and we found a thing, so we can quote the thing. But then we get to the conclusion where we say the district attorney may choose to step aside along with the whole of her office. But why? That doesn't make sense. Why does the entirety of her office have to step aside? This conclusion does not flow from the case law that we just spent an hour reading. In the court's interpretation of that case law, I might add. Because again, there's other interpretation of the case law. But the court's interpretation of the case law is a plausible reading of the case law. You know, it may be wrong on a de novo standard, right? So the Court of Appeals could obviously disagree with it because it's de novo, entitled to no deference. But it's a plausible reading of the law. But given that reading of the law, how do you reach this conclusion? The conclusion doesn't make sense. The conclusion is wrong given the premises. Why does the entire office have to step aside when this is, in the context we're talking about, an appearance of conflict case? And you just said in an appearance of conflict case, it doesn't mean the whole office has to step down. Now, maybe there's some special reason that in this particular case, they have to step down. So that's the way, right? You can distinguish that way. You could distinguish this case from the general rule. As a general rule, it does not necessarily require it. Okay, but it does require it in this case. Okay, why? Justify your choice. And it's never justified. It's never justified. He spends 3 pages talking about facts, but never says anything like these facts are particularly onerous, or these facts are particularly egregious, or these facts are more severe than in the prior laws. These facts are more problematic than those concerns. So even though in the prior case law where they said it did not require, because of my specific findings of fact, in this case, I think this case warrants a more severe result. So making something up, which I totally can do because the case law allows me to make something up, which is fair enough, I'm going to say let's disqualify the entire office, even though that's not normally what's required. But the court doesn't actually do that. The court doesn't actually say, doesn't actually connect the dots. It goes through a whole bunch of facts about, here's some issues and blah, 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 and then just goes to the conclusion without actually saying at any point, well, I need to do something special here because of reason. They just kind of skip to the end. It's the question mark in the underpants gnome, right? That's the thing, right? Prosecutor did a whole bunch of things that are questionable. Question mark. Therefore, the entire office needs to be disqualified. And it's like, could you show your work a little bit more on step 2, please? That'd be great. See the statute cited? Yeah, the statute cited talks about the procedure for replacement of the office. That's what the citation is. The citation is to, okay, given that the office is recused, how do you go about finding a new office? That's what that citation is. So if you choose to step aside, then here's how to go about doing that, or something else. But the court just spent all this time talking about the case law. If the citation to the statute was the thing, they wouldn't have spent the time, right? If the statute was the thing, they'd just be like, oh, it's commanded by case law, or it's commanded by statute. They're like, well, here's what the courts have said about these various things. So, I see the citation. It just doesn't do what you think it does. It talks about being the office, not just the DA. Yeah, I understand that in the statute. If you disqualify the entire office, then here's the procedure for finding someone else, right? But why do we have to disqualify the entire office? Because the court just spent an entire paragraph telling us why we don't have to disqualify the entire office. So the statute isn't triggered because we don't have to disqualify the entire office, because the court just spent an entire paragraph telling us why we don't have to. So it doesn't make sense. Yeah, you're seeing the point? Yeah. So Interior Family Students, thank you for being a member for 11 months. All right, so options on appeal. Options on appeal. Well, there's options on appeal for sure. Now, findings of fact are a no-go. So anything that resembles a finding of fact, just give up. The court is the finder of facts. Court is the finder of fact, and the standard is clear error. No reasonable juror, no reasonable court. Just give up all hope on the findings of fact. So what about the cell phone data? What about this data? What about that? Just give up all hope on the findings of fact, right? The court has gone through the facts it thinks that are relevant to its determination, and other facts are not relevant to its determination. So like a juror would be able to do, they have determined some facts are not as relevant as other facts, and they've reached a conclusion based on a assessment of the facts that is a reasonable combination. So give up all hope on challenging the facts. Give up all hope on how about the cell phone data. Give up all hope on, anything that's a statement of fact. So just abandon hope. The appeals are on the law, right? The appeals are on the law. The Trump's team and the other people for that matter, because there's like 9 of these guys, point, they can appeal on, well, you found all the facts requiring them to recuse, And so they have to recuse. They can argue kind of what I've been arguing, right? That's, you know, not really what the court said. That's not really what they were trying to say. That was dicta, blah, blah, blah. The Court of Appeals is almost certainly not going to give them what they want, and the Supreme Court of the state is almost certainly not going to hear it at this time. But, you know, it preserves the option for the future. You have to bring the appeal, preserve the issue. So, yeah. Yeah. Who's the confusion benefit more, Trump or Fani? Or Fani? So if we're looking to reverse who has better options, they both kind of have decent options actually as well, because the district attorney can very reasonably object for the same reasons I've been objecting this entire time. Like, the district attorney's appeal looks like basically everything I've been saying for the last 2 hours or whatever it is at this point. Like, look, this doesn't flow from your own premises. You just spent all this time telling us how that maybe the district attorney has to recuse, but not the entire office, if they want to make that appeal. I'm not sure they necessarily want to make that appeal, because Fani obviously wants ball. So she doesn't really have an incentive to appeal, I don't think. Although she might be controlling it from behind the scenes, even though she swears she's not, right? But she wants the ball. She wants the ball because she wants to be the person. She wants to be the person bringing the case. She doesn't want someone else bringing the case. So she could theoretically appeal on the basis that why disqualify the whole office? But she wouldn't bring that, because that doesn't do her any good. Her only good is to disqualify her. And there seems to be enough case law. And she can argue that. She can absolutely argue there's not enough to disqualify her. She can argue from the examples we've been pointed out that this is not enough to disqualify her. Or even that the case law is being misread as to that actual or perceived conflict of interest. So Fani definitely has options on appeal. Trump's options on appeal are basically to be like, but why isn't her entire office disqualified? You know, so they can be like so Fani must be disqualified. So that's their appeal. So they both have appellate options. They both have options. And what do I think happens at the Court of Appeals? I think the Court of Appeals kicks the can down the road. That's the most likely scenario. The Court of Appeals kicks the can down the road. They say, the Court of Appeals says, look, you know, they say, even though step 2 is a little bit vague, we'll fill in step 2. You know, even though step 2 is a little vague, we'll fill in step 2. You know, this is a case that requires extraordinary attention, and, you know, the trial court didn't point out why, but we're gonna point out why, because all the elements are there. All the elements are there. So they're just bridging the gap, right? You have all the facts that you need to draw the conclusion. They just didn't draw the conclusion, and they did not draw the conclusion. Like, we'll fill in the gap, because the conclusion is a predicate to the ultimate remedy. So that's what I would kind of expect. I would expect them to look for any reason to, would be my expectation. Because why not, right? And Fani absolutely kicks Wade off the bus, because of course she does. Well, you know, Wade might even voluntarily withdraw, you know, because of Fani. So, I mean, that's, yeah. So they both have appellate options. I think it's unlikely Willis appeals, because they'll just force Wade off the case, and Wade doesn't have any basis to. So Trump will appeal, and they'll appeal on the basis that you have to disqualify the entire office for the reasons we've discussed. The court's reading of the precedent is wrong, which is a fair argument. And the Court of Appeals is going to defer. The Court of Appeals is going to say, well, we read that one sentence, literally that one sentence, in that Georgia Supreme Court, and we're bound by the Georgia Supreme Court, don't you know? So we can't possibly do anything else. So, you know, we're bound. And the Georgia Supreme Court isn't going to take cert at this time. Not a chance in this world. The Georgia Supreme Court takes cert, so we're back to trial. And maybe we deal with those issues on appeal, and the Georgia Supreme Court's not going to care. They're going to kick the can down the road and not care. But that's the most likely scenario. That's the most likely scenario. They're going to look for any reason to uphold this. They know Fani looks dirty. They know as long as everyone else that Fani looks dirty. So the only other thing they could do is force her off the case. But that seems unlikely. You know, it just seems unlikely. It just seems unlikely the Court of Appeals is going to force the district attorney off the case. It is the district attorney. There's valid considerations there. And you can credibly argue, honestly, you can honestly credibly argue that this is not the same kind of corruption as the other kinds of corruption. It's not an incentive to prosecute because she knows the victim. It's not an incentive to prosecute because she has been wronged in some way, that she's trying to seek a personal vengeance. Not that she, you know, represented Mr. Trump or something like that, right? Her corruption is a monetary incentive, which is a secondary incentive. So you can reasonably and credibly argue that the corruption is not as serious, particularly because the amounts are relatively small by the court's own factual findings. The court says we're talking about $12,000 to $15,000, which, you know, is not great, but it's also not, you know, the end of the world. It's not millions of dollars. So you can credibly argue the corruption isn't that serious, especially within the findings of the law we're trying to talk about, which I think is a valid argument. You know, like there is, because we're talking about the remedy, right? The remedy, what do we do about it? And the corruption not being as serious is a valid consideration as to the remedy, right? Because not all crimes are created equal. That's a valid consideration in any crime, right? Again, I tell you, the guy's guilty. I tell you, the guy's guilty. What should we sentence him to? Well, wouldn't it be really helpful to know what he did first? Wouldn't it be really helpful to know like more details about exactly how he did it as we're trying to figure out a sentence for him, right? So this isn't that bad is a perfectly valid argument in every case in a criminal trial. This is not that bad. That's as valid in a murder case as it is any other kind, right? This just is not that bad of a murder. Other murders are worse. This is less bad of a murder. And that can be a perfectly valid argument, depending on the circumstances. So you're saying that she did a bad, but it's not that bad, and therefore does not require this dramatic of a remedy is a perfectly valid conclusion. You don't even have to like be like particularly obtuse to draw the conclusion. Like, yeah, it's bad, but it's not that she was harmed. It's not that she was wrong. It's not that she was seeking personal vengeance. It's not that she's playing both sides of the fence. It's maybe she got $12,000 to $15,000. It's not that bad. So we don't need that severe a sanction. So you could uphold it for that reason, and that would be valid. You know? And by the way, for what it's worth, the trial court could have reached different conclusions, and those also could be valid. And this is part of the thing that sometimes makes people uncomfortable, because it is possible that a different court looking at this exact same set of facts might have said, you have to recuse yourself. And at least hypothetically, it's possible that a court of appeals would uphold that too. Because again, you're talking about what the remedy is, and you might be asking a question, not is that invalid as a matter of law? So you might not be asking, hey, is kicking her off and kicking her entire office off, is that wrong as a matter of law? You might not be doing de novo. Maybe you're doing abuse of discretion of review, because it's effectively a sentence being imposed by the trial judge. Maybe that's the right way to look at it. So if you're viewing it as a sentence being imposed by the trial judge, now you're into an abuse of discretion analysis. So if the court had in fact kicked her and her entire office off the case, would that be an abuse of discretion given these facts? And you could possibly answer that question, no. That would not be an abuse of discretion. And then also turn around and say, this is not an abuse of discretion. Because discretion goes pretty wide. It's not infinite, but it's pretty wide. You know, this is like what we talk about. Like, you know, you have a crime that's 1 to 15 years. You know, the statute by its own terms, for example, contemplates something between 1 to 15 years. And so maybe the answer is 15, maybe it's 10, maybe it's 5, maybe it's 1. And I don't know if all those answers can simultaneously be correct in a case, but a large swath of them could be all valid in the same case, you know? So I don't know if every possible answer 1 to 15 is valid, although the statute even contemplates that possibility that maybe every possible answer is valid. And maybe any answer is as valid as any other answer, because it's an abuse of discretion analysis. Maybe that's the correct way of viewing it. Because for better or worse, we give trial judges a fair amount of discretion. That's part of their job. The Court of Appeals is not here to retry everything. The Court of Appeals is here to figure out they fucked up so hard that, you know, it requires a do-over. You know, did you really fuck this up? That's what the Court of Appeals is there for. So yeah. So you could actually disagree with this decision and be right at the same time, in some sense. Disagreeing with this case does not necessarily make you wrong, because, you know, if you do all the proper analysis and you kind of think it all the way through and you get to the end and you're just like, you know, in the end, I think this, and that's reasonable, you can be right and the court can be right. And that's the uncomfortable part. You can both be right and you can both be wrong. That's sometimes the uncomfortable part of it. Her name is a bit dumb. That's true. But that is not a fact that is relevant to this analysis. Should have made her pay restitution? That would have been good. That would have been good. Pay her restitution. All right. Well, through 351 of you, I lost about 300 people watching this video. I did have 660 people watching this video, and I lost 300 of them. So I'm not sure what that means to me as a creator when it comes to doing deep dive legal analysis. Apparently 300 of you, half my population, did not really want to do a deep dive legal analysis. So I'm not sure what that says, what message that sends to me as a creator. You know, I think unfortunately what's true is that people just want a very visceral reaction, and they just want, you know, an indignity, and they just want to be rah whatever team happens to be. And it's like, well, you know, here's what I want to do. I want to actually read the decision and think about it from first principle and see what I think. I don't think people actually like that. Maybe I should have just been here like, I can't believe this judge. I can't believe she sees the far street. Judge is just wrong. Fani Willis is obviously corrupt, disqualifier, blah, blah, blah. You know, maybe I should just come out here ultra-right MAGA, put on my MAGA hat and be like, this is a disgrace to the system. This judge should be impeached, removed, and disqualified, disbarred, and put in the stocks for all of time. I think is what people wanted to hear, but I had a more considered analysis. Or they had to get back to work. That's fair too. Although, you know, if I was really truly entertaining, then even work wouldn't keep them away, right? Work wouldn't keep. They're just so enthralled. Outrage does put blood in seats. Only it leads to a microcosm, right? Not another micromouth, right? Right. I'm Republican and I'm conservative, but I actually have principles. I know, and principle over party. I know, it's amazing. I might be the last one left. The reason I'm Republican in the first place is because I believe in certain principles, but I believe in the principles. So I apply the principles. So principle over party, right? I don't know whether or not that makes me a rhino or not. Am I a Republican in name only because I'm willing to disagree with the party? I don't know, but I actually have principles. So you guys can figure that out for yourselves, I guess. And incidentally, for what it's worth, by the way, before I overstate my claim, I'm not necessarily saying that people who have a different take are necessarily inherently wrong either, by the way, because there are potentially multiple valid ways to look at this, I sort of illuminated earlier. So some people might have a much stronger take one way or another, and it doesn't necessarily mean their take is wrong, although if it's particularly strong, I would question how well informed it is. You know, are they really particularly well informed, and are they really coming to the conclusions because of reasons, or are they just dead set to reach a conclusion because they hate/love Donald Trump? Like, I hate Donald Trump, therefore this, or I love Donald Trump, therefore this. How about I love the law, therefore this? How about on some level Donald Trump and Fani Willis are some level irrelevant? Because on some level the law itself persists more than Trump more than Fani. How about that? That's a fun idea. Not everyone wants rage bait. Yeah, well, a lot of people want rage bait. I think Nate the Lawyer, and again, no disrespect to Nate the Lawyer, I haven't seen his content, but people in chat have been telling me that Nate the Lawyer raged pretty hard. And he had 4,500 people watching his. I didn't. So maybe the rage was the way to go. I don't know. Yeah. He saw it and he didn't rage. I mean, I was just basing what people said secondhand. Obviously, I didn't see it, so I can't. Sue Candle says, "Oh, Kurt, I miss Republicans like you. Not extinct. Scary times for democracy. I truly fear. Expat vision from Europe." I know. Like, we believe in things because we believe in things, right? And we can change our beliefs, but we want to change our beliefs in a systematic way. That's sort of the way I think about it. I think in systems and policies and procedures, and I think in principle. I try to have a rule that I can apply universally, consistently, without contradiction. That's the goal. Like, I want to be able, and that's one of the reasons, incidentally, I'm so eager to read the merit briefing in the immunity case. Does Trump have immunity? Does Trump have absolute immunity for his official acts while he was in office? And I don't know. I don't know because I can't figure it out. Because it seems like the answer must be yes, and it also seems like the answer must be no. And it can't be both yes and no. It's like, it seems like he must have immunity, but it also seems like he can't. Like, that doesn't work. That's illogical. Can't believe both those things at the same time. So I'm very eager to read the merit briefs because I want to be able to actually figure out, what do I think? I want to read them and be like, what do I think? Can I solve this? So that I can think about this in a universal way, so that I can apply it consistently. Yeah, after many years, this is the first time I've heard you say your political affiliation's leaning. Yeah, I don't normally bring it up. Someone asked and I mentioned it. I've mentioned it from time to time. It's not something I've never mentioned, but it's not something I typically mention. Because why? It doesn't matter. Either my analysis is good or it's not. Either I'm legally sound or I'm not. And also, incidentally, and not for nothing, I actually believe in conservative legal principles, which are decidedly not the same thing as conservative political principles. And I believe in conservative legal principles more than I believe in conservative political principles. And I've illustrated that before too, because I see myself much more as a judge than I see myself as a politician, because I believe much more in the legal principles than the political principles. You know, so if, for example, the United States Congress in its infinite wisdom passed a 95% income tax, and I were on the Supreme Court, I'd be like, what the hell do you want me to do about it? Not because I think the 95% income tax is a good thing, and certainly not because I would have voted for it, but I'm a judge. What the hell do you want me to do about it? Right? So that's what we're talking about. We're talking about the difference of conservative legal principles versus conservative political principles. Conservative legal principles such as, well, you know, the Constitution sets out the power of Congress, and one of the powers of Congress is to tax on income. It says so right in the 16th Amendment. I distinctly remember reading that, and as long as Congress has any reason that makes any sense, they can do it, right? So the only reason to say no is because it's arbitrary and capricious. So we're going to assume, for the sake of argument, it's not arbitrary and capricious, which, you know, Congress has to try pretty hard for it to be arbitrary and capricious. And as long as it's a universal tax and applies to everyone, it makes it a lot less arbitrary. You know, so it's like, well, you know, what the hell do you want me to do about it? They have 16th Amendment authority, and they passed a bill and it got signed by the president, and what the hell do you want me to do? So it's like, I have to vote to sustain it. Because what do you want me to do about it? Right? So it's like, this is what we're talking about. Yeah. And any other number of examples. Or Scalia, like the flag burning case, is a good example. Scalia commented many times he didn't like that vote. He also said that he never took it back. Scalia was also quoted, I believe on more than one occasion, by saying that he didn't really like freedom of religion on a personal level, because freedom of religion implies that there's more than one valid religion, and there's only one valid religion. It's Catholicism, don't you know? He said that. He says freedom of religion. I don't believe in freedom of religion because that implies that there's more than one correct religion, and there's not. There's only Catholicism. Catholicism is the one true way. But did he vote that way? Of course he didn't vote that way, because that's what the Constitution says. It says freedom of religion. He didn't agree with it personally, but he still voted that way because it's what the Constitution said, because that was his job, which I endlessly appreciate. That's a good thing, to be able to separate those things. Like, that's good. Way to go. Good on you. And, you know, that's fine. As a Federalist, the judge would align more along with conservative principles. I have no particular problem with this judge for the major part. I only have one major criticism of this particular judge, which is, how the hell did you come to this conclusion about disqualifying the entire office? So that's my only major criticism. Like, this doesn't make sense. I don't know how you got there. I don't know how that works. That's my only really major criticism of the reason. Otherwise, I think it's fine, even if, and up to the fact that I necessarily wouldn't say certain things. And I definitely would think about it in a different way. I'm not sure I'd ultimately get very much further on the result. I don't know what result I'd ultimately get to, but a lot of this probably tracks very closely to my thinking, even though it would deviate in significant parts too. But that's okay. The White House call? It's possible. Who can say? Who can say? I would imagine that he's getting pressure in any number of other ways. Who can say? But, you know, as a lawyer might say, I only know what I can prove, right? I only know what I can prove, and I can only argue from what I can see. And so, like, maybe the White House called, but, you know, if they did, I can't find it in his opinion. And I doubt the White House would be saying, you know, if you're going to disqualify Fani, we really want you to disqualify the entire office. That doesn't sound like something to say, right? So, because he spends all this verbiage on, you know, we should disqualify, he spends all this verbiage on Fani should be disqualified by not the office. I doubt the White House is the one saying, you know what you really should do? Disqualify the entire office. That doesn't sound like something the White House is. So I'm going to go against it. All right, guys, I'm going to sign off for now. I have work to do, and I need to actually do that work. So I have work to do. But it's been fun. And I've enjoyed our time together, as interesting as it's been. And means or in the Supreme Court. Yeah, that's funny. I'll remember that. Oh yeah, I remember that debate. I know exactly what you're talking about. Yeah, I remember that. That'll be fun. I'll cover that at some point. I don't think I'll cover it today. I have too much work, but I'll try to get around to it. All right, my friends, I've had a good time. I've been on civil law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.